the amount mentioned in the table, whichever is lower. This is the table given, table 1. The first part we are not there. Second is all SB account. This is an SB account. Here the maximum liability will be 10,000. And then further, if the delay in reporting is below 7 working days, the customer liability shall be determined by the bank's board approval policy. We are not in the third because we have reported on the 4th day. 8. Overall liability of the customer in third-party breaches as detailed in paragraph 6.2 and 7.
So the incident happened when? When was the amount misappropriated or taken out from the bank?
Amount was taken out, your lordship, on 2nd to 4th.
Huh?
2nd, 2/10/2020. No, sorry, 3/10/2020 and 4/10/2020.
And 4/10/2020. And when did you inform the bank?
It was informed to the bank on, your lordship, I think, just it was informed on 9.
9/10/2020.
And the FIR was subsequently filed.
When?
On that day itself. After they say that they informed us to approach the authority, the police authority, so that they will thereafter.
So you mean to say, irrespective of whatever has been happening, if there is a, let us assume the bank had, there is no swapping of the CMOs.
Yes.
And you receive a particular amount, message, and you inform within 4 to 7 days.
That is the
Then in that regard, the limited liability would be only 10,000.
That will be the minimum, maximum. Whichever is lower. So 10,000. Here is the case of 8,89,000. So 10,000 limit my liability. That is what I believe from this whatever stated by the RBI circular. Again, your
So you
this
therefore
is also
say,
given very clearly in
if
para
it is
8,
if it is a case under 7.1,
7.1.
7.1 is a case where it is the fault of yours.
Yes, it is the fault. And then that is why I will come to
7.2
that.
is not a case of a fault of yours or the bank.
Then my liability is up to 10. That is what I. Then
But
that
this is
also
only, there
clearly
is a delay
indicated
of
in
4 to
paragraph 8.
7 days working
Your Lordship,
after
kindly take up-
receiving the communication from the bank. So assuming the communication of the bank was given on the date, that is on 3rd.
3rd and 4th.
3rd and 4th, if these informations were given, then also the limit, the
I'll get
liability
it.
would be 10,000,
10.
nothing more than that.
That is what. Kindly, your Lordship will peruse para 8 also. Overall liability of customer in third-party breaches. This is a third-party breach. As detailed in paragraph 6.2 and 7.2 above, the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system, is summarized in table 2. Now, table 2 here, your Lordship is given. Within 3 working days, zero liability. Within 4 to 7 working days, transaction value or the amount mentioned in table 1, whichever is lower, that is 10,000. Beyond 7 days, it's as per the bank approved policy that we are not. Then there is also a reversal timeline for zero liability. Here, since it is not a zero liability, that will not come.
On
But
being notified
burden
by
of
the
proof has
customer,
also been given you.
the bank shall credit shadow reversal of the amount in the unauthorized transaction to the customer.
Within 10 working days from the date of such notification
And
by
also
the
at
customer,
that
without
time
waiting
to
for settlement of
date
interest
any
claim.
customer liability.
This is up to the bank. Then your Lordship would see the liability burden of proof has also been given, specifically at 12. The burden of proving customer liability in cases of unauthorized electronic banking transaction lie on the bank. Now, there is specifically here, the police report has clearly indicated that the customer has no liability because it was absolutely a SIM swapping bank. So, neither.
So to make it the long story short,
Short.
you are on 7.2. 7.2 and eight,
eight,
eight, where it limits itself to
10,000.
10,000, nothing more.
That is basic.
So this SBI has to pay you.
That is what I would like. And-
Yes,
and
SBI. What do you have to say?
So, my lord, this case is covered under 7A, my lord. Before that, my lord, I want
7A.
A, my lord.
Where's A?
A. Yes, said that in this circular dated 17, my lord, page 60. That was my lord, affidavit reply respondent number 9, my lord.
Where is 7A? I know
Yes,
7A.
A, sorry, my lord, 7-1. A, page 60, my lord.
Hmm.
A customer shall be liable for the loss occurring due to unauthorized transaction in the following cases.
Hmm.
The cases where the loss is due to negligence by a customer, such as where he has shared a payment credential, the customer will bear the entire loss until he reports to unauthorized transaction to the bank.
Hmm.
That means, my lord, here is that, my lord, if suppose, my lord, he informed three, my lord, total transaction was happening in third and fourth, my lord. If he inform on third, my lord, if in later on after third, my lord, if any fraudulent transaction is happened, then bank is liable. Here is the case, my lord. In this petitioners, my lord, kindly for a moment, my lord, kindly my affidavit in reply, which was filed by the 6, 7, and 8, 9, my lord. Then, my lord,
Then tell
then
me.
here, my
No, let us assume. Okay. As you say, that the customer has shared the payment credit.
my
You want to blame the customer. Now, if that is so, how do you interpret 7-2?
My lord, 7-2, my lord, come when whether, my lord, customer a bank have no fault, my lord. Here,
Give us a very good, vivid example.
when, my lord, but, my lord,
Give us a example. When can this happen? When the customer is not and third party element. How do you think?
my lord, sometime, my lord, but, my lord, here is the case.
We will take up the matter at 3:30 because I'm taking up bench 1. I'll take it up at 3:30. Think about a vivid example. Okay? No, not 3:34. Take up a vivid example
Well,
as to how 7-2 will.
my lord,
Why? What is the example of 7-2 and what is the example of 7? That's the simple answer.
Yes.
If you can give us a vivid example where here is the case, the customer's SIM was taken for a ride by Airtel. Airtel made all without various documents they have done. The Airtel thereupon, after doing that person concerned, they have taken out the which is found from the investigation. From the investigation, it transpires that the money has gone to a particular person's account. Separate, you have seen all the documents, all what has been stated by the government. The money has been taken by reports have been given, although the charge sheet has not yet been filed. But as of now, this is the investigation. Now, the fact that the money from the petitioner's account has been taken, where the petitioner did not do so, it was taken by third party. That is the fact which is apparent. Then, under such circumstances, when the petitioner reports to you, you say to the petitioner, go and file an FIR. The petitioner files an FIR at your after filing of the FIR by the investigation carried out finds that there has been a SIM swapping of the petitioner for which the petitioner was not a petitioner did not provide the details. Therefore, I am asking you, how do you give a vivid example to differentiate 7 1 and will hear you at 4 o'clock.
Right.
That we can finish the
Item 2.
Yes, what is this? Such a big file.
Another writ petition.
This is arbitration data, my lord.
Arbitration, what am I doing with the CRPIO?
This is the second round of writ petition. In fact, the first writ petition, my lords had passed an order.
Let us know what Mr. Hero has to say.
Yes.
Tell me,
My lord.
why are you against, why are you, have you approached?
Actually, Lordship has directed on 7/1/2022 to dispose of the section 34, and otherwise, if not, then if we can press for the vacating application.
Huh?
Vacating application. Lordship see that order and
We will look into that. First, show me where is the impugned order.
impugned order. That is page 384. ma'am.
Yeah. This is an arbitration petition. The order has arisen of the petition for modification, cancellation, petition, and pending the petition effect. This is 36.3.
Yes.
It's a proceedings under 36. What stay?
They absolute stay, my lord, expiry stay, my lord, granted on the ground that there will be multiplicity of the
Then?
So we, my lord, filed a vacating application in the trial court, my lord, and the matter was heard, and
They got a stay.
they got to stay, my lord.
And then you filed an application.
Vacating. That is it.
Then what happened?
Now that is the order, my lord, on page 384, my lord. Lordship see the reasoning, page 395, lordship has being agreed on top, my lord.
Wait. Now, this order was passed when?
This order was passed on 10/8/2023.
386. There's one order passed by me also. What is that, man?
Yes, that is, you will find lordship at page 380. My.
If the petition is filed by open jurisdiction, then what happened? They disposed of.
That the section 34 could not be, my lord, then we pressed for this application, my lord, vacating application. That was disposed of, but after 1.5 years, my lord, 10/8/2023.
Then
We are before a lordship, that petition was rejected, my lord, that operative portion, lordship may see page 395. That order dated 10/8/2023.
But why is it taking so much of time for disposal of a section 34?
That is my lord, all about that.
Hmm?
Because sometimes presiding officer has changed my lord.
In fact, on two occasions. This is the third honorable
Because we have urgency.
And it was fixed on 22/9/2023 for arguments.
Yes, even today also is this your argument. My lord.
Then?
Section 30.
Complete your argument.
Yes, right, sir, we do, my lord, but we don't know how long it will take, my lord.
Why?
Because the lordship knows that last 1 and now it's almost 2 years, my lord, that section 34. Now after they will go a bit now. Only problem is that they
No,
para
both
58.
of you are making a hill out of a
Yes, very
mountain.
correct. Very correct.
100%.
See, my
A
para
section 34 application is limited.
limited, my lord.
One
I
has to
understand that, my
only
lord.
look into as to whether the case is made out within the ambit of section 34.
Right, correct, my lord.
Then-
But we have urgency, lordship, I have stated in para 28, my lord. Page 18, my lord.
Yes.
Urgency because the tanks are blocked since 2018. Now the
What are
matter-
blocked?
2018, my lord, the tanks were blocked since that auction date, my lord. Now we are 2020.
What is the stay granted?
Stay granted,
What was
my-
the award part?
award is passed in my favor, my lord. Rejecting their claim of that money which they deposited for the group oil, that was rejected. So the lordship may see the direction, my lord, page award, my
Where is
lord.
the award?
154, my lord.
Where is the relevant portion?
last paragraph.
Para 21, my lord.
Hmm?
Para 21.
Where is the relevant portion? The award.
154, my lord.
The
It's
impugn
154.
award dated 21/5.
In fact, 153 onwards. Page 1.
We deem it appropriate to mold the receipt. Presented to the subsequent receipt to the- So here the award is at page 154. The respondent shall, that is you, shall immediately initiate steps for selling away the balance quantity of rupees of so and so kill of club oil relating to the deed between the parties and complete this process within a period of 3 months. Respondent's counterclaim for rupees so and so is allowed. Respondent shall make refund to the claimant the total amount realized by sale auction of the balance quantity of crop oil lying with the account after deducting the counterclaim. simultaneously the account of such occurs shall be furnished to the claimant. Claimant's demand for interest. Now, what is the claim of the claimant?
It is around 5 lakh, my lord.
Now, what is their case in the claim?
That is money decree, my lord, because
No.
they are claiming the money which they have deposited with NRL.
Yes, yes. What did you ask
Because
for?
the issue was that we participated in a bid with regard to lifting of a slop oil, my lords. We are MSME. We qualified in the bid. The tender was awarded to us. Now, in between, a circular from the state government comes where I operate, my lords. I operate from state of UP. A circular comes that a particular one individual, one MSME cannot hold more than a particular amount of slop oil. It's a fact that we had deposited the entire amount pertaining to this tender in advance, along with the security deposit. So we now approach before the Lord's NRL and we say that this is the difficulty. Now we can't really lift the entire slop oil. And there were other disputes also. And therefore we requested that you please refund us the money. We had lifted a particular portion of slop oil. Dispute arose, my lords. Goes before the arbitrator tribunal. Tribunal does not decide the claim in totality on merits, says that we'll do conciliable justice, and it says that let NRL re-auction the slop oil, realize the amount, and adjust their counterclaim as well as whatever amount you have given. What NRL does is they sell the slop oil in
They
minus 80% less price.
Now, have you sold the slop oil?
No,
Yes.
we could not,
Yes,
because
yes.
in between they got the stay.
Slop oil is sold. The only thing is that the slop, if I may just take, the slop oil has not been lifted because we got a protection from this honorable court. Otherwise, my entire 34 would have become infructuous. Had the slop oil been lifted also after they've tendered it, bidders participated, awarded, amounts also paid. The only this was supposed to be done within 3 months as per the award, my lord. That's another point that would have taken my statutory right, which is available under 34. So we move before the court and we request the court that look, if the slop oil is lifted, my 34 becomes infructuous.
Right.
My lord, it's already
Did you ask for the slop oil?
yes, my lord.
They have not.
Did you ask for the slop oil?
When, my lord? In the first hand, yes.
No, in the tribunal.
Yes, my lord. No.
That is
No.
That's not your case.
My
Your case is, if I understood from you,
yes,
is that there was a tender for auctioning of slop oil.
please, my lord.
You participated.
Please, my lord.
You made the payment.
Please, my lord.
And then, in view of a state government circular whereby there is a limit imposed upon an MSME to hold the slop oil, you say, kindly refund us the money, take back the slop oil, we are not lifting.
Yes, my lord. I may just stand corrected, my lord. My lords, it was the circular, my lords, that the circular was there from before. In fact, they had a nodal agency which had to scrutinize all the documents pertaining to every bidder. There were other bidders also who participated in the tender. We submitted entire documents.
Your case may come under 56.3. That's another aspect of the matter.
That's right, my lord.
But the question of not selling the circuit slop oil.
No. Lord, if I may just say that, I understand what is calling. My lords, what happens is that the tribunal does not decide the entire issues on merits. My lords have seen that, my lord, at 153, that's why I pointed out, 154 is the direction, lord. 153 is the reasoning for the direction. If my lords want, I can read it, my lord. But
No, not necessarily, but let us assume
yes, my lord.
the tribunal does not decide.
Yes, my lord. So
what is your course of action?
Yes, my lord. So what tribunal does is, it balances the equities.
Understood. What is your course of action then thereafter?
My lord, the course of action would be that if my friend's client has to sell the slop oil through auction, my lords, then he has to ensure that he realizes the maximum amount and does not sell it in a throwaway price, because ultimately my rights are affected. My entire money is blocked. So what happens? That is the problem, my lord. Had the slop oil been sold at a reserve price, my lords, we would have not been here before, my lords. But what happens is that slop oil is sold at minus 81% of the original price.
But isn't that a subsequent cause of action?
We had no knowledge about it. We were not even informed.
Yes, they are acting on that.
Yes.
But wouldn't that be a separate dispute?
Look, if I may say so, my lord, it may not be for the reason, my lord, that it flows from the award, my lord.
No, no, they may sell it, but the amount which is to be taken out there, you may ask for that, whatever may be. You may ask for setting aside the award, not taking into account these are the circumstances which has happened. That is another aspect of the matter. But can you stop them
Lord, we
from selling the stock?
have not stopped them, my lord.
Isn't that what is the order pass? Let us
Just kindly see the order,
what
my
is
lord.
the award pass, the stay order pass?
Yes, my lord.
272,
That's
my lord.
272.
Huh?
272.
Lords and
Annexure
my
11.
lords will also, my lords, we are conscious that it was during the peak COVID period, my lord.
So?
Because when the market is also on a lower side, my lords would appreciate that during 2020, everything was hit, my lords. All the businesses were hit.
So there must have been a less price.
That's also the, my lords, the only difficulty.
It must
my
have
lords,
been the reason out there. Considering the ground and appearing when you are operation, how can you steal this award like this?
lords, but I am only of the view, my lords.
But your cause of action, whatever you are saying, maybe we may stall. We may modify this order only to the extent that they can go ahead with the sale. But the question of imposition upon you as regards the difference shall be only stayed, not the 39 lakhs. 39 lakhs is already been quantified. You paid it.
May I also say that, my lord, there are many things in that. May I just point out one more thing? Because as far as the counterclaim is concerned, my lord, we have taken a specific ground in 34 that there is no clause which deals with the ground on which the counterclaim has been. So that's there, my lord. So I'm
maybe,
saying that it's all,
but whatever may be, we are to follow as per the provisions of Order 41, which has been mentioned out there. So under such circumstances, you pay that amount of 39 lakhs. We are staying. We will be continuing to stay. Let them go ahead and selling it. We will stay the risk and cost factor, which is being imposed. Yeah, that to recover from you that amount, that will stay.
the money is all, my lord, if I may say so. The entire money is with them. This is not, if I may just explain, 6 odd crores is paid to my friend's client in advance before participating, before award of the tender. We had to deposit that amount. So it's not as if NRL is in any loss. There is no loss to that effect.
Not sell it. If they are not in a position to pursuant to an order, award, they have now taken up for selling of the stock.
That's right, my lord.
Now that slop oil, are you going to, they are having a quantity of slop oil. Are you ready to pay the what you call the charges for keeping the slop oil?
Milos, I have an understanding, Milos, that slop oil has been passed on to the bidders, Milos, because no bidder has raised any objection till now since 2020.
I'm not concerned. You undertake to pay from that,
but I have
from the date of the stay.
order in my favor, Milos.
No, you don't have an order for that. That stay order, we are modifying it. We are going to do it only from that time. You are going to pay all the expenses for that. They will keep the store.
In a writ jurisdiction, Milos.
Huh?
In a writ jurisdiction, Milos.
This is not writ. This is 227.
227. There is no jurisdictional error, Milos.
Where? That order? Absolutely.
Because they have not taken any.
That order has been disposed. First of all, the jurisdictional error of the court below is they have not disposed of the Section 34 application.
Then may I just explain this, Milos? Just give me 2 minutes.
And then rest is for the Supreme Court to decide.
Just give me 2 minutes. I'll explain it. Just give me 2 minutes.
Oh, wait,
see my lord's order.
No, Mr. Chairman, I am not comfortable with this order.
I'll just take 2 minutes.
No.
Kindly just see 2 minutes.
The rest is for you to stay.
60 seconds.
No, sorry.
Just kindly see my lord's own order, my lord. What does it say, my lord? In fact, they filed a...
How could the court stay it in this manner? And then when there is a specific direction passed by this court to dispose of the matter, they have not taken up. They have taken it at their own will.
I may just say so, my lord. If, my lords,
you can't do that.
If a court has stayed any arbitral award, my lord, rather than contesting 34, there being no provision of filing stay vacate, they file a stay vacate, they delay the proceedings, my lord. There is no my lords are aware, my lord. In Arbitration Act, there is no provision of filing stay vacate application. And it is very clear there is a mandate to finish the 34 within a year, my lords. Now they file a stay vacate. Now the stay vacate, reply, counter, written submission, argument. That's how, my lords, when it came in the first round before my lords will recall, my lord passed a detailed order and my lords gave that direction.
But this
my
is
lord,
not happening.
that either
The
you,
court is not doing it.
Look,
The court
I-
should have disposed of the 34 as soon as possible.
if I may
They are
say
not
so.
doing
No,
it.
no,
The
my lord,
court
if
should
I
have
may
been
say so,
more
there are
responsible.
practical-
Rather than writing a long order out
Look,
here for vacating the
look,
stay,
look,
that was not necessary.
May I just say that, my lord, it was not like that, my lord. After my lord passed an order, my lord, the order direction was very clear, my lord. Either dispose of 34 or decide the stay vacate. That was, my lord's, precisely my lord's direction. Now, my lord, it so happens that we go, both of us, we argued, judgment reserved, my lords, the honorable judge, my lord. Then, my lord, as she then was, she is elevated, my lord. Then, my lords, we go before the new bench, my lords. We argue the entire case, my lords. My lords, the honorable judge superannuates. Now, my lords, this is the third occasion. My lords, we are by consent, we have taken a time of today.
Why have you taken the time again?
No.
You have
To
taken
argue the
time today?
case.
No, today's the date of hearing is there.
Have you
Yes.
taken time there?
Yes.
No, we did it.
No, we have. We have.
We have not taken time, my lord. This is a misleading statement, my lord.
I'm taking this
Time.
matter on again on what you call. Time has not been granted
No,
till now.
we have not taken time, my lord.
No, for argument.
My argument today is the date for argument.
You have
Yes,
not
yes.
taken time.
No argument today.
My lords,
You will be arguing today.
Yes.
join.
We'll fix this matter again on 13th, on which date you inform us what is the next stage as to whether the arguments are complete. This is the second round of
My
litigation.
lords, may I just
No. Do whatever you do.
No, only one
This
request.
is a second round of litigation as regards a disposal of a stay vacating application in respect to a proceedings under Section 34 of the Arbitration and Conciliation Act 1996. The application under Section 34, which have been registered and numbered as arbitration case number 34/2020, have been pending before the court of the learned district judge, Kamrup Metro at Guwahati, since 7/10/2020. That is almost more than 3.5 years. In spite of the statutory mandate provided under Section 34(6) of the Arbitration and Conciliation Act, which stipulates that the said proceedings are required to be disposed of within 1 year from the date of appearance of both the parties. In fact, the said aspect of the matter was brought to the attention of the learned district judge by the order passed by this court on 7/1/2022 in WPC number 5616/2021. However, in spite of that, the learned district judge, Kamrup Metro, learned court of the district, had taken more than one year, 7 months to dispose of the application seeking vacation or modification of the order dated 7/10/2020. And against the said order, the instant proceedings have been initiated. It has been informed to this court today informed to this court today that today is the date fixed for hearing in the misarbitration case number 34/2020. It has also been mentioned that the hearing would take place today. Taking into account the above, this court further fixes the matter on 13th of March 2024 on which state the learned counsels appearing on behalf of the parties shall apprise this court as to whether the hearing of the said proceedings have already been completed or not. This court requests the learned court of the district judge Kamrup Metro to take up the hearing on day-to-day basis so that the same is completed, preferably on or before the next day. I'll pick it on 15, on or before the next day. A copy of the instant order be provided to the learned counsels by the court master today so that the same can be placed before the learned district judge Kamrup Metro during the course of the hearing.
Can I request for 20th if my lords have no issue? 20th, my lord, if I can request for it. 50 instead of 15, 20th, my lord.
You can have it on 14th. 14th.
Not actually, I'm out on an.
I can't help you get some other
I'm
counsel.
only request. Let
Mr.
it be
Counsel,
15.
I can't help
Let
you.
it be 15th, my lord.
No,
I'll 15th.
complete the hearing.
15th, my lord. Let it be 13th, my lord.
No, 15.
15th, my lord.
I have to give you. Are you not a senior counsel?
Limited item
If
20.
you are a senior counsels are daily wages. Somebody else will appear. You engage somebody else if he is not in a position to marry you. Mr. Decker, you take a copy of this order, he will provide you. And madam, you take a copy of this order. Show it to the district judge during the. Huh? What is this? Item number 3. Item number 20. 20. Yes, what is this? Who is on leg? What do you want? The appellant is not appearing from such a long time. I can't know. What is this? Appellant is not appearing from 2021. That is why it has been delayed. You are asking for it. Who is appearing for the respondent? You are asking for enhancement. Huh? Are you asking for enhancement?
I have a
It is a case of enhancement. Yes,
Lordship, I am appearing in behalf of the respondents, Your Lordship. This matter got dismissed in the year 2022, Your Lordship. Thereafter, we have returned a brief to the company, Your Lordship. But till that, we have not received any instruction in that regard, Your Lordship.
was it at all admitted at any point of non-representation listed in here, non-appears for the sense on day. Next year, next day. Since none appears to and not we are really dismissed for none appears again. Was it again
Yes, Your Lordship.
restored?
Yes, Your Lordship. It was dismissed on 2022 and it was restored on 2024, Your Lordship.
24.
Four.
And then also the appellant did not appear.
On the last occasion.
And the records are here. We do one thing. We finish it off. Finish it off. I don't see any infirmity in the order. Let us finish the matter. You have no objection if I dismiss the appeal. You have any objection? You want the extra file?
Yes, so that can be.
Extra file, Asini? Yes, tell me. I don't see any good reason. You have not proved you have only given one witness as regards the 3,000 rupees, 12,000 rupees. That is not the proof. The proof has to be on the basis of there is no other evidence given. So we don't find any infirmity.
I think that's part of time.
I mean, you have paid the money.
Your Lordship, 50% we have deposited.
And remaining?
Remaining, Your Lordship, because the matter was dismissed, Your Lordship, I have to obtain the instruction in that regard, Your Lordship. I'm not aware.
Why haven't you not paid the remaining amount? Who is going to pay the interest? If it is dismissed in 2022, you should have been you should have paid it. The appeal was filed by them. Then why haven't you paid the remaining?
In that case, Your Lordship, that's because it was dismissed on 2022. Probably they have paid, Your Lordship, till today.
Okay.
Not paid.
Mr. H. Buragwai, the learned counsel, appearing on behalf of which insurance company?
This is, Your Lordship, United India.
United Insurance Company. United India Insurance Company. Seeks for some time for obtaining instructions as to whether the amount as awarded by the MAC in MAC by the award dated 8/8/2014 in MAC case number 83 of 2013 have been duly paid. This is the matter when?
After 1 week, Your Lordship.
Okay, list the matter again on day 7, 11 on 14, on 14.
Obliged.
AM 27.
Yes, Mr. Vati.
My lord, essentially,
Yes.
my lord, essentially, this suit is for declaration of title, right and not for the payment of the compulsory section 80.
Huh?
This suit was for declaration of title, right and not for payment of the compulsory section 18 of the Equity Act. For this purpose, my lord, may I take your notice?
Just 1 minute. What was the suit for declaration of title, correction of records, and for perpetual injunction?
My lord, your lordship, directly, my lord, I am taking your notice. Then, at page 64, 11 for the 64, my lord, top of it. Sorry, my 64. And the prayer portion, my lord, your lordship, sign. At page 68, my at page 67.
Yes. See your plane.
Yes.
Page 66. See paragraph number 10, 11, 12, and 13.
That the construction of proceed terminal by chain. That is right, madam. But even though my report
Huh?
declaration of my title.
Against whom? Against whom?
The, dependence number.
No, Mr. Bhatti. Your suit is these suit land have been acquired for the Dhubri terminal.
Yes.
You are entitled to the compensation. That is what you say. And however, the defendants in Group 1, Group 2, and Group 3 are overcrowding in the land acquisition branch and claiming compensation. And that is why you have filed a suit. So it is a case of that you are entitled to the entire compensation, or it is a case that you are entitled to part of it. Now let us read section 18 of the no,
Yes,
Mr. Bhatti,
that I
kindly read 18 of the land acquisition.
in that case, my lord, that I allowed to file the application on section 18 for reference at the time.
This was done when?
It was-
2010.
Yes.
We have 14 years. Has the money been paid?
Still the money is not.
You're sure?
Yes, I'm still today it is not.
It's still lying with you.
Yes.
Money?
Not.
Huh? Money has not been disbursed.
Not been disbursed.
Mr. O.P. Bhatti, the learned counsel appearing on behalf of the appellant, submits that due to wrong legal advice, the appellant who were the plaintiffs have instituted the suit being title suit number 420 of 2010. And thereupon, the proceeding which were continued, leading to the filing of the instant appeal, have been all under wrong legal advice. He submitted that this is a pure and simple case wherein the question arises as to the entitlement of the compensation between the plaintiffs vis-a-vis the defendant, numbers 3 to 10, which the plaintiff ought to have filed an application under section 18 of the Land Acquisition Act 1894 for seeking a reference so that the collector could have made the reference to the learned district judge of the within whose jurisdiction the said land had been acquired. He further submitted that a perusal of the entire proceedings would show that the petitioner, on account of the wrong legal advice, have been pursuing bona fidely and diligently the entire proceedings, for which the period during which the instant suit has been filed till date ought to be excluded while computing the limitation for filing the application under Section 18. He further submits that he may be permitted to withdraw the instant appeal and pursue and the plaintiffs be permitted to pursue the remedies under Section 18. This court have put a categorical, had put a pointed query upon Mr. O.P. Bhatti, the learned counsel, as to whether the petitioner's objection to the award, what would be the objection to the award for which the counsel, Mr. O.P. Bhatti, the counsel for the appellant, as to what would be the objection to the award under Section 18 to be filed. The learned counsel submits that the objection to the award shall be limited only You have the Land Acquisition Act. Would be limited only as regards the person to whom the award was to be payable, would be payable, and not in respect to any other objections. This court have also asked put a query upon Mr. T.R. Gogoi,
Here go.
appearing on behalf of the
Respondent number
respondent number
1 and 2.
1 and 2,
Right.
and as to whether the amount, as to whether the awarded amount have been disbursed or not.
Or no.
The learned counsel submits that as per his instructions, the said amount has not yet been disbursed. So, taking into account the above, this court closes the instant appeal proceeding and grants the liberty to the plaintiff, who are the appellants herein, the appellants herein, to file the application under Section 18 within 42 days from the date of the instant order. The said objection under Section 18 of the Land Acquisition Act 1894 shall be only limited to the persons to whom, only limited to the persons to whom it is, the award is payable. Persons to whom the awarded amount is payable.
Lord.
in the whole period, and nothing more.
But it is my telephonic instruction that amount is still laying the
So I've said only instruction.
Lord.
I didn't say about verbal or anything.
Lord.
You have instruction.
Lord.
This court have also taken note of the orders passed by the learned trial court as well as the first appellate court, wherein on account of jurisdiction, the suit as well as the appeal have been dismissed. It is also seen that the petitioners herein, the appellants herein have been pursuing the remedies on legal advice diligently and bona fide. Under such circumstances, this court, therefore, is of the opinion that the petitioners herein would be entitled to, the appellants herein would be entitled to the benefit under Section 814 of the Limitation Act 1963. With the above observations and directions, the RSA stands in support.
My lord, yeah, it is. That may not. Still,
You file your,
I file here.
I'm not
Still
going to say anything.
Still I file.
They have not done it. I've given you, so you know what to do. So don't go to stall your visit to Rajasthan if you are so kind to your client.
But, okay. 28 for orders.
Yes, what is this?
It is a lot.
Why review?
What will lot in this case initially state Colonel Manoranjan Goswami was appointed as the arbitrator by
Hmm.
the court of. Now, present arbitrator who has been appointed was the secretary to that arbitral tribunal.
Huh?
The present arbitrator who has been appointed subsequently on the application filed by the other side was the secretary to that arbitral tribunal. Now, after that was filed, we realized that he was appearing a case against two cases against the MES same in one case particularly to the side division.
No. What is this reply? What is the review? Why the review has been
Review
filed?
seeking for a subsequent lottery to review that or not to appoint someone else. No.
Present application has been filed seeking appointment of a new arbitrator in lieu of the earlier arbitrator who has passed away. The fairly submitted is no objection of a new. Accordingly, so and so, an advocate come life member of the Indian Council is appointed as the arbitrator. Okay. Parties will appear before him. Then now what happens?
She was appearing case against us, Lordship. So
Who?
when we pointed out that
Momita Bora. Okay,
arbitrator-
now whom do you want?
From, okay, as far
Lordship,
as per requirement,
Lordship, my submission is there. She has never been appear in favor of me in or before any court also. She is new to me. Or Lordship, one thing is the arbitrator is
Mr.
the
Counsel,
Lordship.
Mr. Petitioner in person,
Lordship.
you want, whose arbitration it is?
I sought for the arbitration, sir.
You want an arbitration to be done?
Lordship.
Let us do it in a fair manner.
Lordship, that is in a fair manner, Lordship. Lordship, what happened actually? When the arbitrator has been appointed, with their consent only, the judgment the Lordship can see. With their consent only, the appointment.
Now, tell me whether the newly appointed arbitrator this was done when?
In
2022.
No.
Now 22, the 2019 amendment has come in. In fact, that order is wrong out here. The court should have first asked her to give the declaration under 12.5. Without the 12.5 declaration, this order could not have been passed. We review it on that ground. Forget about that. Now tell me whom should be given a part.
Lordship, my submission, may I submit, Lordship? Lordship, may I submit?
Whom do you want?
Sir, I have
No, not her. She's
Lordship,
gone. This order is reviewed. Don't worry. Now the question
Lordship,
arises. This order on the face of it is contrary to section 12(5). First, the thing how it is should have been done is the court should have asked the arbitrator, whomever, to furnish before this court a certificate that she has nothing to do as regards this. Then only the appointment could have been made.
Lordship, the judgment is like that only.
That is not there.
Lordship,
Kindly see, where is that? Page 11 is the order.
Lordship,
Mr. Chakraborty?
Lordship.
Yeah.
10 and
Accordingly, she so and so is appointed as the arbitrator subject to her consent and absence of any impediment as mentioned in this. This can't be done.
subject to consent, Lordship.
Subject to consent means she may give a consent, but she has to give a declaration before the court that yes, I have nothing to do with
Lordship,
this project.
Lordship, kindly, I want to submit, Lordship. They have submitted everything.
Remaining submission is the one. No.
Oh, 136, that is true, Lordship. That is what the 7th judge judgment also said. They can file an
Seven judge judgment is 7 judge judgment has whatever has been said at that point of time in 2005, 7 and 6350 is the judgment wherein what has been stated out there has already been taken care of, and now it is being brought in by the 2015 amendment.
Lordship, there is
12.5. 12.5 was not there at that point of time.
Judgment 2020 also says of the Supreme Court,
What
Lordship.
does it say?
Review it filed with the Supreme Court under Article 136. They may approach the Supreme Court, Lordship. But
It's a
Lordship, what happened? Lordship,
We will say it to be a procedural review. Don't worry. If 114 does not apply, we still have the inheritance.
Lordship, one
There was a
submission.
mistake.
Sir,
A review lies. Review doesn't lie in view of 11.6. 11.7, it
Yes.
says that the review does not lie.
Lordship,
That
yes.
is the reason why you are saying.
Lordship. And 11.7 says it become a penalty also. Penalty, the judgment given by 11.6. It is a final judgment, and a review has to be applied under Article 136.
Now you do one thing. Mr. He's right on that. What does
on
it say?
review, on mandate
Supreme Court?
Copy दीजिए मुझे. Copy दीजिए.
Okay, paragraph 11 now. This is passed in a review petition. Okay. Paragraph 11 now.
पार्टी के नाम पर चाहिए. कौन सा ये
2019.
2009.
Document and there is also paragraph 7 on the factual aspect.
This judgment is on section 9. And during the course of a hearing under section 9, it was decided that the person so and so will be the arbitrator. So under such a one, nobody approached under 11. But how do you take off 11.7? I think you need to file an application under section 13.
But we can read this as nomenclature should not be a barrier to give.
Huh?
If the relief is due, Lordship, the
So this
nomenclature
is
should
wrong.
not be a
There's no
barrier.
quarrel. This is wrong. But then this court. In fact, this order is also wrong. On the face of, if a person dies, how can the court, High Court appoint it? Tell, show me that. Yes, Mr. Sir, petitioner in person, show me. If the arbitrator dies,
Lordship.
can the High Court exercise 11? See section 13, 13, 14, 14, 14. Seeing the petitioner in person, I thought that you must have sought for a review of my earlier order where I gave it to you. That was,
That was separate case lot.
Huh?
That was separate case lot.
I gave two orders in your favor, huh? With the petitioner in person.
But it's in the-
Isn't it? This order on the face of it was wrong. Now, under such circumstances, the appointment out here is wrong. The court could not have exercised it. Let us see what happens when a person is dead. At least 12, 12, 13. Failure, 14. The mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator. 14. If he becomes secure or unable to perform, he withdraws from a agreed or agreed to termination of his mandate. If a controversy remains concerning any of the grounds referred in clause, a party may, unless otherwise agreed by the party, apply to the court to decide on the termination of the mandate. So, under such circumstances, this termination of the mandate would have been, or if under subsection 3, an arbitrator withdraws from it or a party agrees termination of where it shall not imply acceptance of the value of the termination in addition to this referred to a mandate of when it withdraws the state of the
Lordship, I have a sufficient that the e-jude factor can be invoked, Lord.
Huh?
E-jude factor can be in view of 12.5. Subject
In
to your
view of?
Lordship approval, Lordship.
No, in fact, this order is wrong.
That's why, Lordship.
If the person has died, passed away, then it should have been a fresh application at best for appointment. Or if the arbitration proceedings have started, then you have to move the court. And the court would not mean the court under section AF because here this is not the court. On the face of it, this order is wrong. So why can't then I not exercise? Not under 11.7, but on the face of it, the order is wrong.
But you can exercise 215.
Tell me, the petitioner in person,
Yes, sir.
whether arbitrator has hired. There are two options available. If the arbitration proceedings have started,
Lordship.
then it would you require to move the court under section 14
Lord, for termination of mandate. Lordship.
for termination because it automatically has terminated. So you move under 14 for appointment so that the arbitration proceedings are continued from the point the arbitrator has left. But if the arbitration proceeding did not start at all, then in that case, you can move under 11. But how can you file an IA in respect to the matter in under 11?
Lordship, this court has appointed earlier arbitrator who has passed away. Agreed. Lordship, what happened? This court appointed arbitrator has passed away. This court has two more power to again appoint the arbitrator, Lordship.
How?
Of two more, because firstly, the court has appointed
Show me that
arbitrator.
provision. How does this court have the sumoto power?
If
If the court has the
it is
sumoto
understood.
power, then the court also has the sumoto power to review. Not possible. Very difficult. Or you can do one thing. Why should we go into all these things? I reject this application and give it the liberty the district court under section 13
So
for termination.
giving me the liberty to file the application under 30.
Under 13, challenge the petitioner. The parties at the media about the theory for termination. The ground which you are using is considered a bit of 13.2.
Yes, but 13.
Has she given that
No,
that arbitration proceeding? Has she given the 12.5?
no, Lordship.
She has not given 12.5. How can she proceed?
Lordship,
That is a requirement.
that is the requirement.
Notwithstanding anything prior agreement to the contrary or any person whose relationship with the party or counsel of event falls under any of the categories specified shall be ineligible to be appointed as arbitrator.
Lordship, after we file an application before her Lordship, at page 31.
Huh?
We filed an application before her, that will Lordship find at page 31. She gave the reply, Lordship, at page 34.
Page 31.
31, we filed the petition seeking declaration on 12.1, Lordship. Paragraph number 3.
Further, it is submitted that you have not yet circulated the requisite disclosure in writing under section 8 with conjunction of the you have reduced the part of that minute where it is not or so you have done that.
Done that, and the learned arbitrator has given his her reply, Lordship, page 35.
34.
34, the relevant the paragraph that deals
As
with
per
that
the
is at page
direction of the
35.
honorable arbitrator, both the parties were parties were
At page 35. Start from further.
have submitted a letter taking some education into and made that right is the best way. Also,
Lordship, why we are afraid, Lordship? In a work contract of 27 lakhs, she has passed an award of 1.3 crore against us. She was the arbitrator. What
That is-
contract value was 27 lakhs that I have annexed, page 36. She passed an award of 1.3 crore, Lordship. Lord will find the what contract value, page 37. The claimant quoted and the same was accepted for an amount of rupees 27, 87, 399. That
Mr.
was the value of the
GD,
work.
Lordship,
Yan, you have something to do with this thing from of this order, Annexure C,
Annexure C of which chapter? Annexure C.
My
SR Engineering Construction.
Yes, sir, Lordship.
How are you connected?
sister.
I'm the
concern.
partner of that.
So in that, she has already passed an award.
That is a different contract, Lordship.
So what?
That is not related with this contract, Lordship. This is a matter of GD engineering construction. That
what?
is SR
Same thing.
engineering.
You are going to appear in both cases.
Yes, sir, Lordship.
Well, what is the claim amount?
Lordship, the reason of passing of that is 35 years old, and if that interest, that part, that is calculated. Otherwise, whatever the dispute, she has passed it also. That matter is 3.5 years old, Lordship. Decade old.
And we have put this effort to challenge. Lord will find in the above document, page 48, on claim of loss and profit. No amount has been specified, but she has awarded 14 lakhs on that part.
No, but the claim which was made was 3 crores something and you got only 1 crore. It's not the issue out here. But the main problem is she should have given that. Without that, how can she proceed?
Lordship,
Without giving that disclosure, how can the arbitrator proceed?
Lordship, when the judgment itself speaks about that, on if they consent, he can proceed it. So on
They have not given a consent.
Yeah.
They have not given a consent, has no objection if the new arbitrator is appointed.
Lordship,
You
somewhere
see,
I
Mr.
have-
So-and-so, you see, kindly see paragraph 2 says a new arbitrator, let the new arbitrator be appointed. Somebody died. They said that we have no objection. Then the court appoints.
Right.
The court did not ask for that.
The name suggestion came from the petitioner.
That
Honorable Court. Sugar, I was not prepared for this one. I was only prepared for that one. That review petition is not maintainable. That is maintainable in Supreme Court. Or moreover, the lordship, before submitting a defense, they should have given the objections to also come before the court.
They
That
have
time,
given the objection and then also the arbitrator has not. What is the stage of the arbitration proceeding?
Just it's preliminary stage.
Huh?
Only the
You stay the arbitration proceeding.
I'll submit, lordship. The statement of case submitted, they have submitted pleading of defense, they have submitted rejoinder. One hearing has already been done. Then they have come before this honorable court.
Further proceedings in connected arbitration case arising shall remain suspended. It is stayed. It has already been stayed.
Only because my learned friend, they have come and taken the expertise order from the court. That's why it was suspended till the order of this honorable court. That was suspended actually.
So it is still stayed.
Lordship, okay. It is stayed, lordship, but it stayed at advanced stage. Proceeding is staged at the matter is advanced stage before the learned arbitrator, lordship.
No. We can't allow the arbitrator to, unless the arbitrator submits the 12-5.
Lordship, then, lordship, I may be given a time for section 12 and 13. I'll bring the citation of the different courts, lordship.
Okay,
Kindly
we'll have
give-
it.
kindly
When,
give
when
an
do you
attack.
want it?
3 weeks only.
The request of Mr. Gyansham Das Dhiman, the learned petitioner in person, the learned opposite party in person. Matter stands adjourned. We consider again on 27th of March 2024. Full stop. The arbitrator, Miss Momita Bora, shall not further proceed with the arbitration till the disposal of the till further orders passed by the court.
Obliged.
and
Please, Doctor. So
Hmm.
to raise a case, my lord, the petitioner instituted title suit, my lord, seeking my lord partition of the joint property.
Hmm.
Now, my lord, along with that, my lord, injunction petition also filed, seeking a limited relief that the defendant be restrained from alienating the joint property. Only that way, my lord, those who are supposed possessing the land or whatever.
What happened?
My lord, that expired injunction was not granted. Page 53, my lord. In a very casual manner, my matter has been dealt with. No doubt not been rejected, but my lord, ultimately, it says about provision of law. My lord, provision of law says something else, my lord. 39.
Okay.
And the MP order contained in page 53. Now, Lord, the middle paragraph third. Upon careful analysis of the above observation and going through the provision of law, I am of the view that it would not be just and proper to pass.
None has appeared.
My lord, application we have directed to my lord, check that.
Who is Pobin Deka?
My lord, Bobin Deka is one of the part of that, my lord.
Huh?
Family member, my lord. My lord, he is the respondent number 30. And
Response
he also
number?
village head also of that village.
Hmm?
Bobin Deka is the
Bhavani
one of the
Mohan
son
Methi,
of
Lapanna Methi, Aman Methi, Archana Methi, Archana Methi, Bhumika Methi, Bhumika Methi, Tibatit Methi, Methi, Pobin Deka.
he is also the village head, my lord, and he accepted the notice and stated that he distributed all the family members.
Why was it given only to the village
My
head?
lord, day before yesterday night, my lord,
Huh?
8 p.m. My lord, 7, 8 p.m. My lord, they enter into the village, my lord. And my lord, their distance are
This
very,
can't be the service, Mr. Samaria.
my lord.
You could not have given.
At least 13 has to appear, my lord.
No. I have taken steps to Dusty, and the same has been duly affected upon him.
No, my lord. The line
Your
I have
statement
begun-
is wrong. I am the engaged counsel of the appellant, and as per the direction of this court, I have taken steps upon the respondent to Dusty, and the same has been duly affected upon him in due course. It is relevant that the copies of the interlay have been also received by the by respondent
All the-
on behalf of who is the family relative of all the How do we know?
My lord, the thing is that, my lord. At least 13
You
has to
see,
appear, my
if
lord.
a service has to be done, the service has to be done in accordance with Order 5. If it is the Dusty service, yes, it has to be given. Either you give it to the family member. Do they stay in the same locality,
My lord, he's a family
in
member.
the same house?
My lord, 13 is the family member. He is the head, my lord,
What?
village head
Head.
also. And he informed us that he would.
Are you saying everybody, all the 1 to 13 or 1 to 16 reside in the same locality?
Yes, my lord. Only one is at Morigaon.
Hmm?
The question of 13 also didn't appear, my lord. At least he knew about this, my lord, service of court.
I would have understood that, okay, 13 to 16 is okay. But what about the others?
My lord, there also.
How
my
are you
lord,
connected?
residing nearby, my lord, of that locality.
There
And my lord,
is
since
no
it
service.
was delayed, my lord, at night, some apprehension was also there that,
Why did you go at night?
my lord, because we received the notice from that town hall about 6 o'clock, my lord. At 6 o'clock. Therefore, immediately we proceeded, my lord, with that of the local person. And once we, my lord, met them, they said even from that 13 is the proper person from whom they have collected. At this point, my only humble prayer that let them appear. Again, we'll take it step. You don't demand that question is that, my lord, a little protection may kindly be granted, my lord. At least status will be maintained. We will also maintain, my lord. We are also posing on part of that particular problem. We will not alienate anything.
What are you asking? What status
My
quo you are?
only thing, my prayer is that limited alienation should not be allowed. My lord. Let them do anything, agriculture activities, constructions, or whatever, my lord. Only alienation, but it creates a very big problem, my lord. Specifically, we have pleaded in our list.
Where is your statement
My
that
lord,
they are
can you
going
see
to
paragraph
alienate?
17, page 44. 17 and 18.
You are asking for restraining from entering into the scheduled land
My lord,
and from carrying out any agricultural activity. This I will have to reject.
my lord, no problem. 18, my lord, tell me. 18.
Only status quo as regards possession, status not to alienate.
My lord.
But I'll reject the other aspect.
My lord, no problem.
The instant first appeal is directed against the order dated 25/1/2024 passed by the Court of the Civil Judge, Senior Division Number 3, Kamrup Metro at Guwahati, whereby the learned court below, the learned trial court, refused to grant an ex parte ad interim injunction in the injunction application file, which was registered and numbered as Ms. J case number 70/2024. And fixed the matter on 12/3/2024. when the appeal was taken up on 4/3/2024, this court had admitted the appeal and directed the appellant to take steps upon the respondents by way of dusty routed to the registry of the court and file an affidavit of service on or before the next date. Pursuant thereto, the learned counsel, Mr. Sandeep Samare, had effected steps upon the respondents herein by serving copies of the summons along with the other documents, along with the memo of appeal and the injunction application, to the respondent number 13, as well as it has been stated that the respondent number 13 had accepted the summons, the dusty service on behalf of all other respondents. Taking into account the above, this court have also again reconsidered the submission of Mr. Sandeep Samaria, the learned counsel appearing on behalf of the appellants, who submits that the appellant herein are not insisting upon the prayer made in the injunction application for the present. However, limits its prayer only to maintenance of status quo as regards the title of the property, that is to the effect that there should not be any alienation of the suit property till the next date. This court have also taken note of that the trial court would be taking up the injunction application on 12/3/2024. Under such circumstances, this court passes a limited injunction order till 13/3/2024, to the effect that the parties herein, that is both the appellants and as well as the respondents, shall not alienate the suit property till the next date. The appellants are further directed to place a copy of the instant order before the learned trial court, as well as also so that on the next date, the learned counsels, the respondents, so that the respondents before the learned trial. This court makes it clear that under no circumstances this court have restrained the learned trial court to proceed with the injunction proceedings or the suit. This court further, for the sake of clarity, makes it clear that a limited injunction order shall only be limited to alienation of the suit property and nothing further.
Only 14, my lord. Letter 11 to 13 letter options I have given, my lord. I would be, letter options I have given from 11 to 13. Lord, can you repeat the 14?
14.
What?
But Mr. Samaria, I think you should further effect upon everybody. The petitioner, the appellant is further directed to take justice service upon the respondents, upon all the respondents, rooted to the registry of this court, and specifically upon the respondents and not through a person, not through one person, unless the appellant produces before this court that all the respondents have authorized one single person to accept their notice on their behalf.
If
The same should be filed on or before 14/3/2024 by way of an affidavit.
30.
Yes, what is this?
Automatically, your lordship.
Delay.
Yes.
What about the other side?
It's not complete, your lordship. We have taken that as per this post with 80, your lordship.
Service not complete.
Away service report is
Whom do you want to serve?
the
Nihal Goswami.
Yes,
Why you are not able to serve? The record reveals that the service upon the sole respondent has not yet been effected. So stop taking into account the above. List the matter. The appellant is further directed to take fresh steps
your lordship will take fresh steps with regard to the usual process.
by registered post on or before 13th of March 2024 upon the sole respondent, and matter be listed for consideration after completion of the service.
Your lordship, as per usual
You have not taken steps usual. Then
process.
you take steps taken by registered post.
For hearing item number.
Yes,
Second, it will again be judgment
whether
of
the suit
compound-
has been rightly decreed in favor of the after more than 12 years of possession of the suit land by the appellant. That's a question of fact. Whether on the basis of an offer given by the plaintiff during maintenance proceedings can be the basis for granting a fee for right title and interest and possession after 16 years of such economy. Yes,
That the respondent that plaintiff filed a suit for declaration of right and of for recovery of
respondent have filed.
They,
They have filed a suit
they have filed a suit
for
for declaration of right and for recovery of possession.
uh,
My lord, the plaintiff's case in brief was that he was married to one Nilam Nath in the early part of
where is the
Like-
plain?
plain, my lord, is that is at 39 to 43, my lord.
Respondent is Dharmeshwari Devi, plaintiff. Who are you? Dimbeswar Kotani.
Investor Khan is no more now. Investor Katoni, now his heirs are before your lord.
Okay. The declaration of title and recovery of possession. Plaintiff number 1 was married. Dedicate Nilam Nath. Nilam Nath, very son of Kapani. So his basic case is that the plaintiff was married to one Lilamnath,
Nilamnath, my lord.
and Lilamnath, there is no divorce,
Though there was no divorce,
and
my
as
lord.
such has asked for half of the property of Lilamnath.
My lord.
That's
But
the
here,
entire.
my lord, the defendant is the elder brother of Nilamnath. Plaintiff's case was that he was married and he gave birth to a daughter. And her marital discord, when her minor daughter was about 2 years old, she left her matrimonial home for good and took shelter in her maternal house. Thereafter, my lord, she filed a maintenance case, seeking maintenance from Lilamnath, her husband. During the proceeding, there was a compromise. An ekranama in writing was executed. That is Exhibit 4 of the defendant. That was executed on 11/4/1967. The ekranama, my lord, are we allowed to read?
Married when? With Lilamnath?
Ekranama,
No, madam. When the marriage took place between Lilamnath and the plaintiff? When?
marriage. My lord, according to her, she was married in the early 60s because the daughter was born in 1962.
60?
62.
Then
She left for her
and when did
matrimonial home.
Lilamnath die?
Oh. And maintenance proceeding was instituted. And during the maintenance proceeding, there was a compromise. Lilamnath offered to give half of his share to the plaintiff and the minor daughter. That compromise was made on 11/4/1967. The Exhibit 4, my
Was there any divorce?
there was no divorce, my lord.
Then
There was no divorce.
why will the plaintiff not get the amount?
No,
the land?
my humble submission before Lordship that this ekranama,
Forget about the ekran.
no,
We are not concerned
because
with
the
it.
back,
No, madam, we are not concerned
No,
with
my-
the ekran.
I have-
No,
no,
kindly come. A simple thing.
no,
No, madam. Let
no,
us first.
I-
No,
I-
madam. I will
I
come to you.
understand, my lord.
Okay, I will come to your ekran number first, but later on. But first, tell me whether there was a divorce.
There was no divorce, my lord.
So
According
the
to my-
plaintiff continued to be the legal wife.
Yes, my lord.
Now, after Lilamnath, did Lilamnath have any property?
He inherited from his father.
So therefore, he will be entitled to.
Actually, they will be entitled to the entire share of Nilamnath
Huh.
as the class 1 heir, my lord. But why I am submitting ekranama, that was their basis, my lord. That was their trump card. Because for 13 years, Nilamnath was living. He died in the year 1979, December.
Mm.
During his lifetime,
Mm.
no specific performance of contract was sought. Nothing was sought, my lord. So it got time barred. Then subsequently, what they did by taking the plea that her daughter has come of age, so they filed this suit. Now the plain schedule may kindly be read. Schedule is a half share. That means according to ekranama, my lord, their basis is ekranama. Though they are not saying in so many words, their basis is ekranama. And ekranama, it was executed in 1967 during his long life.
Madam, tell me one thing. Let us have the ekranama, it's a trump card or whatever. But as per Hindu Succession Act, she is a class 1 hai.
Yes, my lord.
She will be entitled to half of Lilamnath. she'll be entitled to the property of Lilamnath.
In absence of other heirs, she will get inherit the entire property of Lilamnath. She'll inherit entire property of Lilamnath, but he is seeking half share of Lilamnath. Why? Because Ekranama, he made a promise. Lilamnath relinquished that for you and for my daughter, I will give half share of my property. So why I am submitting, my lord, though not in so many words, because the pleading does not say that Ekranama, but
Lilamnath had how many children?
my lord, I am agree because the judgment is also perverse, my lord. My case is, the defendant's case is that though three brothers inherited the property,
Hmm.
Dimbesarnath, the main defendant, there was a settlement in between the three brothers.
Hmm.
Who Dimbesarnath gave up the cattle farm, buffaloes farm, and in exchange, that is the defendant's case, my lord. That is the pleading. That in lieu of that, he took the landed property. The Sarkari Kambura has also, in his evidence, stated that the Dimbesarnath was looking after the immovable property of Pabhai Katoni, the original landowner, the pedestrian interact of Dimbesar Katoni and his brother. So, my lord, my humble submission before lordship, there we have taken the plea of adverse possession also in written statement. Her case is that she went to take share, but she was driven out by Dimbesar Katoni. She did not file a suit within the statutory period. Adverse possession also we claim. Adverse possession also we claim, and simultaneously the Ikranama's case. See,
Where is
where
your
my
written statement? Let us see your written
written
statement.
statement, my lord, at page
Yes.
Uh,
Where is your adverse possession?
44 to 50.
That Lilamnath had having driven away the plaintiff with the plaintiff number 2, married defendant is vague and meaningless and denied. Then on plaintiff had deliberately concealed material fact, Swanson knew that it did not inherit any vested claims to land during her life. And then Swanson knew that Lilam did not inherit any vested claims.
So doctrine of waiver, my lord, hit by doctrine, nothing.
There's no waiver.
The trial
The
court,
right
my
is there. Yes, enough. Yes.
He is the first, admittedly, she is the first wife. They themselves have admitted.
Then
Yes,
where is the adverse possession come from?
there is no plea also in it.
No, no, they have taken a plea, but interestingly, they have said that Lilam Nath had no right. And if you say that Lilam Nath had no right, where is the question of a plea of adverse possession sustaining? You have to acknowledge that he was the owner of the property, and that owner, I have asked him not to come. Then only, if you are not, you are saying on one hand that Lilam Nath had no right of the property, then so matter ends.
Adverse possession means first you admit the title.
And how does these question of laws come 12 years, maintenance, ikramnama, perverse? Nothing.
None of them is sufficient.
Okay, let me dictate.
The trial court just deterred the order without assessing evidence, nothing. Because perversity is also there, my lord. Learned trial court came to a finding that it is believed the evidence of TW2, 3, my lord. Perversity is there, my lord. Taught by limited doctrine of waiving.
Tell me one thing. That property, which is the scheduled property of the land, of the plain, where is the scheduled property of the plain? Let us see. Page 39.
Yeah, my lord. At
Yes. Page
at
42.
42.
This property, half share of the land of late Lilam Nath out of the total land measuring 19 bighas. How did the defendant number 1 get a right over this land?
19 because belong to Bhai Katni,
Huh?
the original landowner.
Original landowner is who?
Father.
Father.
Father of defendant number 1.
No, my lord. Defendant number 1 and the husband of the plaintiff number 1, they are brothers.
Understood. So, if they are brothers, whose property was it prior to? How did Dimbeswar Katoni, who is the defendant number 1, get that property?
There was an amicable settlement, my lord, in lieu of land.
Amicable settlement will come later on, but you have to have a source. Source is where? Must have been the father's property. Is it or not? So
Only-
if the father's property is there, did you prove that Lilam Nath during his lifetime gave the entire property to the defendant number 1?
Is my pleading I have
No. Pleading is not evidence. Did you prove by way of any documents or evidence that the property absolutely belonged to the defendant number 1 during the lifetime of Lilam Nath?
Ramabandi was there.
Jamabandi is only record of right.
Right.
That would not do.
But
Those
there-
type of thing. Enough.
There was an amicable, because my
Okay,
lord, one thing is there.
Heard
See-
Miss P. Chaudhary, the learned counsel, appearing on behalf of the appellant, and Mr. D. Mojumdar, the learned senior counsel, appearing on behalf of the respondent. The instant second appeal was admitted for hearing by formulating the following substantial questions of law by an order date 10/2/2010. The 3 substantial questions of law which were formulated were: number 1, whether the suit has been rightly decreed in favor of the respondent after more than 12 years of possession of the suit land by the appellant, question mark. Number 2, whether on the basis of an offer given to the plaintiff during the maintenance proceedings can be the basis for granting decree of title, right title and interest and past possession after 16 years of such ekranama, question mark. Whether, number 3, the impugned judgment are perverse to the evidence and pleadings, question mark. This court have duly perused the copy of the claim as well as the written statement which have been filed. The impugned judgment of the learned trial court, the judgments of the learned trial court, as well as the first appellate court have also been duly perused. From a perusal of the materials on record, it is apparent that the suit property, suit land, which is half of the land, that the suit land, which comprises of 19 bighas, 16 lechas, covered by old dark number 732, 770, 759, covered by periodic patta number 272 of village Likhok, Gaon, Moza, Bihariguri, standing in the name of stood in the name of late Sabhai Kotani, that is 2 bighas, 2 kathas, 13 lechas. And also a plot of land measuring 9 bighas, 3 lesser, covered by dark number 494, 523, and 602, covered by periodic patta number 243 of village Moilagaon, Moza, Bihariguri, standing in the name of late Sabai Katini, that is 2 bigha, 1 katha, 5 3/4 lecha, total 4 bigha, in total 4 bigha, 3 katha, 8 by 3/4 lechas, belong to the father, belong to one Sabai Katoni since deceased, who was admittedly the father of one Dimbeswar Kotani since deceased, and one Lilam Nath since deceased. The said property,
And one more, one Ferguson not, one Ferguson not, brother,
there is no Kirgeswar Nath.
Ferguson.
Kirgeswar Nath is the son, is the son.
Ferguson not,
And one Fergeswar Nath.
he's not.
Fergeswar Nath. Yeah, full stop. The said after the death of late Sabai,
Katoni,
death of late Sabai Kotoni,
Katoni.
the said property devolved upon the said Lilam Nath, late Lilam Nath, late Dimbeswar Kotoni, as well as late Khogeshwar Nath.
Not.
Also. The plaintiff, she's alive or dead? Plaintiff is dead. The plaintiff, Dharmeshwar Devi, since deceased, admittedly was the wife of late Lilam Nath. Full-stop. It is apparent from a perusal of the materials on record that there was no divorce, that the original, the plaintiff, late Dharmeshwar Devi, continued to be the wife of late Lilam Nath till late Lilam Nath expired in the month of August 1979. Full stop. However, the defendant number 1, late Dimbeswar Kotoni, mutated the entire land in his name and debarred the plaintiff as well as the plaintiffs from any share of the said land. Under such circumstances, the suit was filed seeking declaration, seeking a decree for half of the share of the land as described in the schedule to the plain for mean profit out of the share of the suit land semicolon, delivery of khas possession of the suit land for cost of the suit as well as for any other relief. The defendants duly filed a written statement wherein they had stated that late Lilamnath did not inherit any landed property from his father, nor he claimed any right over the land of his father. Under such circumstances, the plaintiff had no right over the said land. It was also mentioned that, further to that, the plea of adverse possession was taken. Be that as it may, on the basis of the said suit, as many as 14 issues were framed by the learned trial court, and thereupon, by judgment and order dated, judgment and decree dated
29/4/2002.
hmm,
29/4/2002. Trial court does that.
29/4/2002, the suit was decreed in favor of the plaintiffs. Thereby, declaring that half of the share of the land as described in the schedule of the plaint in favor of the plaintiffs, and further, in order to remove the ambiguity and further confusion at the time of the execution of the decree, it was mentioned that the plaintiff would be entitled to half of the share of the property of late Leela Ramnath as his legal heir, which late Leela Ramnath inherited the same from his father, late Sabai Katani's share of the total land of Sabai Katani. Being agreed, an appeal was prepared by the defendants, which was registered and numbered as title appeal number 12/2002. The said appeal was dismissed by judgment and decree dated 7/9/2004. Thereby upholding the judgment and decree of the learned trial court, by thereby affirming. It is against the said the instant appeal has been filed, and this court, by the order dated 10/2/2010, had admitted the appeal by framing the above noted questions of law as substantial, as above noted substantial questions of law. This court, I've heard the learned counsel appearing on behalf of both the petitioner, both the appellant as well as the respondent. Taking into account that the appellant, that the respondent herein, who was the plaintiff, admittedly was the wife of late Lilam Nath, and there is a finding of fact arrived at that late Lilam Nath had inherited the half of the properties of his father.
One third, my lord. One third. One third. Three brackets, one third.
No. It's half. half of
Other property of
have inherited a portion of the property of his father. And as the plaintiffs were the class one legal heirs of late Leland Nath Pusto, the plaintiffs were therefore entitled to the decree as was sought for. Under such circumstances, in the opinion of this court, the substantial questions of law which were framed had no relevance to the issues which have a reason for consideration, for which the said questions of law under no circumstances can be said to be substantial questions of law involved in the instant appeal. Consequently, the instant appeal stands dismissed. In the facts of the case, this court imposes a cost of rupees 10,000.
Lord, that
15,
no, my lord.
20.
10,000 for
10,000.
One correction, both the plaintiffs are alive. Plaintiffs are alive.
Plaintiff alive today.
but it cost very acceptable.
How much?
I happily paying my because they are not.
And
No.
They have prepared
this
my lord,
lady
they
is
have
staying
prepared.
outside, all are inside.
No. Cost of 10,000.
At a vote.
Yes, what is this? Non-appears. Whether the suit being for declaration of title of possession and defendant's appeal, whether the suit being for declaration of title and delivery of that possession and defendant appellant future fee of adverse possession, it was proved by the winner. Parallelly committed error saying that
I am appealing for the respondent.
none. So we have to dismiss for default.
Lord, it appears, my lord, that YK Fukon was there and somebody else was there, some A.G. Borua.
But then also they have not even appeared on 8/2/2004. This court had given a warning. 12/1/2024 also none has appeared.
Right.
None has appeared on behalf of the appellant on call. Mr. B.C. Das, the learned senior counsel, appears on behalf of the respondents. Taking into account that the appellants are not represented on 12/1/2024, 8/2/2024 when the matters were taken up, this court dismisses the instant appeal for default. Full stop. The registry is directed to transmit the record back to the learned trial court.
Oh. Lord, I have another matter, Lord, item number 6.
Okay.
Lord, can it be taken up some other day?
We'll take it up with just for 5 minutes because this whole matters I don't adjourn it. What is
But
this?
I am not able to
Take.
find the queen.
Yes. So you kindly change your position from there to here. Yeah. Yep. Item number 6.
ওইদিকে যেত ওদিকে
Whether the learned court below committed perversity in interpreting the defendant's purchase deed, that is exhibit 4 to exhibit 4, and overlooking the evidence of DW1 vis-a-vis the mutation in the name of the plaintiff while declared to. Yes, Mr. Das.
but I have not been able to see it properly.
See that?
I have not been able to go through it. It's long back, my lord, but it was fine.
So then I will also help you out. For reparation and recovery. take up the matter again at 2, Mr. Das?
Lord, some other people.
No, Mr. Das, I don't adjourn matter. Now, only one thing I'm not able to get it out here. From the evidence, one thing is very clear that 4 bighas, 4 katha, 4 lechas was the land which Masam had. Masam means the predecessor in interest of the plaintiff. From there, 1 bigha of land was sold. And from the evidence of the record keeper, it reveals that this 1 bigha was sold from old dag number 97, which now corresponds to dag number 235. So if only 1 bigha has been sold, would the entire land have been given for then decretal would have been given in respect of the entire land? You see, kindly come to this particular portion of the evidence.
Page 39.
Kindly come to this portion. Yes. Para 12 of the judgment of the trial court, page 22. It has already been stated that the old patta number 42 of so and so contained 34 bighas, 1 katha, 18 lechas, and with 9 dags. In the written statements, admitted that the land measuring 7 bighas, 1 katha of area covered by dag number 235, 236, and 238 is an part of the old land of dag number 97. DW1 in the cross-examination admitted Masam sold only 1 bigha of land to his father from 1 dag. In the suit land, there was 9 dags. In the said sale deed, number so and so saw the boundary of the land show was shown as north so and so, south so and so, year so and so. Record keeper has stated that the old dag contains 7 bighas, 1 katha, 18 lechas covered land. New dag number 235 contains 4 bighas, 4 kathas, 4 lechas. And other 2 bighas, 2 katha, 14 lechas have gone to dag number 236 and 239. That is evidence. Masam Sheikh sold 1 bigha of land to Abdul Majid. Wide exhibit saw from the old dag number 42 in the year 1962. Thereafter, 1968 Singh's settlement, these new dags and pattas came out. Abdul Majid 1 katha from air dag number 236 and 237 from PP Patta new, whereas plaintiff suit land falls on dag number 320. This is not understandable, but one aspect is, what is this selling of these dags? So let us see what is the question of law you have framed. Whether the learner committed perversity in interpreting the defendant's purchase deed, exhibit law to exhibit law, and overlooking the evidence of DW1 vis-a-vis the mutation in the name of the plaintiff while declaring the right title in. So here, therefore, apparently there was some land sold. What was the land sold? If 1 bigha have been sold, maybe the defendant, you are entitled, the plaintiff may be entitled to a part of the decree. But would it be the entire 4 bighas? Or should it be only 3 bighas, 4 katha, 4 lechas? Because 1 bigha was sold. You are dark. Respondent, here you are 2. Yes, respondent, tell me. Tell me how.
In this case, I've been led by my senior Mr. K.K. Mahanta.
Huh?
In this case, I've been led by my senior Mr. K.K. Mahanta. He's on lecture court number 10 here.
So, I told you at 1:15. Show me how that particular dark number. Here is a case where your predecessor, you are the respondent, you are the plaintiff.
I was a plaintiff.
Your predecessor has sold 1 bigha land to the predecessor of the respondent. of the appellants, which is apparent from exhibit or something.
Okay.
This thing is apparent from your affidavit, your written statement, as well as everything which is there in page number 22.
My plain
Exhibit Bhava. From PP Patra number 42, Masim sold 1 bigha of land to Abdul Majid.
we say we have never sold the land. We say the plaintiff say
No, that is the sale deed is already there. But because you have not challenged the sale deed. Committed. That's the exhibit show. Exhibit show is the main. Mr. Mr. Das, do you have exhibit saw with you? This is exhibit saw. Now you see the catch out here, the entire litigation catch out here is this, which I could gather. The total land of Patta number 42. Patta number 42 initially had 34 bighas, of which it had many dags.
Yes.
One was dag number 97.
Alright.
Now, this Patta number 142 was bifurcated, partition, and one part became 147.
Yes, yes.
This Patta number 147 had three dags, 235, 236, and 237.
Right.
235,
Has 40
the land is 4 bighas,
Kolkata,
4 katha, 4 lechas.
Sure.
Remaining is there in dag number 236 and 237. Now, the question arises, you were sold dag 97 because this was done prior to 1968, except one land which was sold by the plaintiff's son, the one of the brothers of the plaintiff, that is Moinuddin, 1 katha 5 lechas, that too in dag number 236. Exhibit Shaw is the most pertinent document, wherein it says that the father of the plaintiffs sold 1 bigha of land to your predecessor, Abdul Majid. This document shows that the land which was sold was from dag number 42, Patta number 42. And it showed dag numbers were 106, 251, 253, 256, 101, 106, 260, 263, 97, 103,
there were 9 ducks.
9, 34 of the 18. So in all these dags, from all these dags, 1 bigha of land was sold. But the question arises as to whether these dags any land from this particular dag fell within dag number 235. Because 236 and 237, we are not concerned. So only question is whether dag number 235 in that land it was there.
No, the defendant's case is that the petitioner interest of the plaintiff sold out other lands also of this area
To others.
to others.
There's no quarrel with that. I'm not on. You're right. You have purchased various lands prior to prior to 68. These lands were in the year 1952, 3 bighas, 3 katha, 15 lechas. In the year 1948, 44, 2 bighas, 2 katha, 5 lechas was sold to one Isab Ali. Isab Ali sold it to you on 2/3/1945. These were all dag number 97.
Yes.
Then Moinuddin Sheikh sold 1 bigha year in 1972. That is dag number 236. He makes it very clear. So there is no problem. So we are at, but whether dag number 235 any land was sold or not, that is the question. Now, you see, let us see how the first appellate
Yes,
court
sir.
dealt with this very aspect of the matter.
Page
Yes.
39.
Para
38.
11.
How it dealt with this matter, kindly see this.
Page 38, para 11 makes it clear, Your Lordship.
Page 38, paragraph.
Yes, sir.
Page 38,
Para 11.
let us not go to para 11 before that. Yes, yes. Before that, if we go, looking into. Kindly come to page 38. Then kindly come to page 38 on top, from top, 7 lines from the top. 7 or 8 lines. However, have you got it? However, from the cross-examination of DW4, it reveals that all dag number 97, there were 7 bighas, 1 katha, 18 lechas. But in the present dag number 235, there is a land of 4 bighas, 4 katha, 4 lechas. And the pattadas were Masam Sheikh, Hamser Ali, Hukai, and Abdul Majid. Which means some portion of your name, your predecessor's name is there.
Also there.
But the question therefore arises as to whether they were entitled to the decree for the entire land or part of it. Then you see, according to dag number here, so and so, of the land of so and so and so and so, except this land, Maman Sheikh did not sell any other land. It is stated that then you come to 11. It reveals from the record that the suit land measuring 4 bighas 4 kara is covered by dag number 235 and periodic patta number 147. It also reveals from the record that in the patta number 147 there are 2 more dags which were dag number 236 and 237. The suit land along with other land were old patta number 42 of so and the total land in the said were 34 bighas 1 katha iman lecha. The new dag number so are part of old dag number 97. So old dag number 97, some portion was sold in view of exhibit Shaw. You see, there were various dags including dag number 97.
Yes.
From the evidence of DW1, it reveals that out of 7 bigha 1 katha 18 lechas of land, new dag number so contains so and the remaining so is contained in there. The plaintiff version is that they inherited the suit land from their father and Maman Sheikh, who was the patadar of the said land. It is also the statement appeared that the father, Masan Sheikh, was possessing the suit land and other land. Subsequently, out of a amicable, the plaintiff got the suit land into their share. In support of their claim, the plaintiff side has submitted the copy of the judgment. It has been alleged by the PW1 that the defendant dispossessed them from the suit land and PW3 had corroborated the pursuant. From the evidence of PW5, it reveals that the name of Masam Sheikh was there in the revenue record. But the defendant's claim is that though the name of Masam Sheikh was there in the revenue records as Patada, but he had no any land to inherit by the plaintiff. The defendant side had exhibited some documents in order to substantiate their claim that Abdul Majid purchased the land in the suit dag and patta from Masam Sheikh and Masam Sheikh also sold lands to others, and thereafter Masam had no other land in the suit Dag and Patta. From exhibit here, it reveals that Abdul Majid purchased the land from the son of Masam Sheikh, but it is seen that the said land was purchased from Dag number 236 and 237.
Out of
Exhibit Shaw, which is relevant, certified copy of the deed goes to show that the defendant so and so purchased 1 bigha from Masam Sheikh, the predecessor in interest of the plaintiff. But it reveals that this 1 bigha of land is covered by different Dags. Likewise, it reveals that exhibit show that Abdul Majid purchased the land from Isab Ali, and by the exhibit Go deed, Abdul Majid purchased some land from Abdul Suham. Exhibit show it reveals that though the land falls in the suit patta, but the land is covered by different Dags. Exhibit Go shows that the land was purchased in the suit patta, but Dag number 97.
Yeah.
Exhibit Ngo, it also reveals that the land is covered by different Dags of the suit patta. It reveals from the record that the present suit land of the plaintiff and other lands were covered by the old patta number 42 of 1930 and 31 settlement. And in the said patta, there were 34 bighas so and so. And the pattadar of this land was Masam Sheikh, Samser Ali, Abdul Suham, the 4 brothers. The defendant's father, Abdul Majid, subsequently by way of purchase of the land got his name mutated in the record of rights. In the settlement of so and so, Abdul Majid was not a pattadar in respect of the suit patta. DW1, that is the defendant, Muhammad Ali, in his evidence had admitted that Masam Sheikh sold 1 bigha of land to Abdul Majid in 9 Dags. DW1 has also failed to say in his evidence the respective share of Masam Sheikh's, Abdul Suham's, Shamsher Ali Kukai in the land of Sutpatta number so and so. From the copy of the deed exhibited by defendant, it does not reveal where the land of the deeds attract the suit land of the plaintiff or not. From the document submitted by the defendant's side, it reveals that the predecessor of the plaintiff sold 1 bigha of land to Abdul Majid, and that 1 bigha was sold in different Dags. As such, though the defendant's side has claimed that the suit land was purchased land of their father Abdul Majid, it has not been proved in the case. On the other hand, it reveals that the Jamabandi that was of so-and-so settlement, the name of the plaintiff was mutated in the revenue records in respect of the land of their father Masam Sheikh, but the said mutation was not challenged. The evidence on record also shows that the plaintiff also filed so-and-so wherein the defendant tried to dispossess them from the suit land, and subsequently the plaintiffs were dispossessed by the defendants and then dissued. The evidence on record also proves the fact that the defendant dispossessed the plaintiff from the suit land. From the above discussion. Tag number, the question arises as to whether the entire decree could have been given when your name was also there in tag number 235.
But to what extent that is not clear?
Huh?
To what extent that is not clear?
No, because isn't this document the chita is a plaintiff document?
Yes.
Yes, it is exhibit number 4. Exhibit number 4 is the chita of tag number 235. There, the name of Abdul Mujid appears at number 4. If that be so, it is not known how much.
Yes.
But can it be said that the plaintiff have been successful in getting the entire land? Tell me. No doubt. Your father have sold 1 biga of land to the father of the appellants in various ducts. But isn't it the burden of the plaintiff to show that he is in exclusive right over the entire dag of 4 biga, 4 biga, 1 katha, 4 lectures, and 4 katha, 4 lectures to get the degree? Then how is it possible, if that is the document and that is the document you are relying, exhibit 4, which also shows the name of the petitioner's, the appellant's father, how could that be the entire decree? Tell me. Give me an answer to that. Entire thing is resolved.
Some accommodation today may be given.
What accommodation? There is no accommodation after hearing. Accommodation is subject to cost. Judicial time has been spoiled. I have not even accommodated the senior counsel when he asks for. No.
Let me go to the record.
This is a case of remand. It's a case of remand. Because if yes, you may be entitled to, you may be entitled at best. You are entitled to 3 bigas, 3 kathas, 3 bigas, 4 katha, 4 lectures of possession. There's no quarrel with that.
Yes.
But can you say that you are entitled to 4 biga, 4 biga, 4 katha, 4 lectures?
In the tag number 235.
That is the question.
Entire land he cannot get.
The decree is otherwise right as regards the other.
But this particular fact did not came out in the judgment of the title appeal.
Huh?
This particular, which is what the question which has been now put to me. This in the
It is
judgment
not
of-
there, but the question is, if you are asking for exclusive right over the entire dark number 235, there's no challenge to the sale deed. The sale deed says about 97. About other lands also as regards 97. They claim the entire Sutpata, the Sut land, the Sutta. They claim entirety. They may not be entitled. They are not entitled to. I'm not saying that they are entitled. But at least they're entitled to some. So can the entire decree be passed for the entire dark? The court put the burden upon him. Isn't it the burden upon you, taking into account that you want that particular thing? See exhibit 4. That is your document. You see Abdul Majid's name. at number 4. That is also 4.
Two 35.
And in your entire cases, the name of Masam Sheikh was all along then, they have nobody challenged it. But along with that, the name of Abdul Majid is also there.
Yes.
Maybe the Abdul Majid may have come somewhere, but they may not be entitled to 4 Viga 4 Katha 4 lectures, but they would be at best entitled to something. So can it be said that you are in exclusive right over the entire Rag?
Abdul Majid name has been strike out.
Where? Not strike off. Where is it? Strike off.
Number 2.
Huh?
First is Sheikh Sheikh Masim.
Sheikh Masam, then Somon Ali, then Kukai, then Abdul Majid, then Moharuddin, Moharuddin, Tawheed Ali, then Abdul Hai. Who is Abdul Hai? Plaintiff's names are what?
Nurul Islam, Akbaruddin.
Huh?
Nurul Islam, Akbaruddin,
And
Safaruddin,
and
and Abdul Sattar, son of late Maharuddin, and Abdul Kalem, son of late Maharuddin. They are all grandson of late Masim Sheikh.
respondents are Nur Islam, so and so Masam Sheikh. Who is Abdul Hai? Isab Ali. Abdul Hai's name is there.
Abdul is number 10.
You see, again, Abdul Hai's name is there. How does
Both
Abdul
are
Hai's
sons
name?
of Isawal.
Huh?
Both are sons of Isawal.
Isab Ali again has sold him.
Yes. Isawal.
How is how can the decree be passed in respect of doc number 35? If Isab Ali's name is there, and then you see another thing. এক নম্বৰৰ লগত মহৰুদ্দিন পিতা মৃত আব্দুল সমাদ। আব্দুল সমাদ, আব্দুল সুহান or Abdul Samad? Abdul Samed. Samed.
Abdul Samed.
Samed. Abdul Samed is who? Yes, Maharuddin. Maharuddin is 8 and 9 out here. Who are the performer?
Maharuddin and Saharuddin are sons of Samad.
And how could the decree be given on the basis of that document? If on the prima facie that document categorically shows This is not Exhibit 4. And there are many people whose names have been inserted in 2001, 2000, 2006 and all.
Exhibit 4 is revenue paying.
And when was the cause of action happen?
It was filed in the year
Huh?
two thousand one.
2001. Now kindly see, চক্র বিষয়ের বিচার 25/5/2000 সূত্রে সত্তৰৰ কাহেদ আলীৰ লগত কটাৰ 235, 236 দাগৰ অংকত এবিঘা 2 কঠা 16 লেখা মাটিত আলি চহৰ আলি নামজাৰি হয়। হুই চহৰ আলি?
Shahar Ali or Shahad Ali?
চহৰ আলি চহৰ আলি চহৰ আলি চহৰ আলি is
Performer defendant.
Huh?
Performer defendant 12, 13, 14. All are sons of Sahad Ali, late Sahad Ali.
Shahad Ali.
চহৰ। No, this is not চহৰ, চহৰ। See?
Shahar.
Now, if that be so, they are not the plaintiffs. How can the decree be given for delivery of possession to you? See the 2001. 2001. It's on the next page. 2001 noting. Just where the, you see that? Namzari.
Sahid Ali.
Sohar Ali. That's a noting of 2001. Some order of Namzari of 2000.
Yeah.
If that be so, in respect of the dark number 235, his name has entered. Then how is it possible without making those people a party?
They were performer defendant.
The performer defendant is Shahad Ali. Shahar Ali.
No. Here the defendants are Ramzan Ali, Firoz Ali, Mirza Ali, Omar Ali, Muhammad Ali.
Yes.
That person's name is not there. Or are you fighting the case for the performer defendants also? So how can the court pass a decree for recovery of possession of the entire land in respect of other persons? Yes, Mr. Monto. I'm delaying and asking your able junior about this. Mr. Mondo, the question is very specific.
Yes.
The entire earlier dark was dark number 42.
Old map, yeah.
Dark number 42 belonged to you, your predecessor, along with his brothers.
Yes.
Which contained, not dark number 42, patta number 42, which contained 34 bighas. Of these 34 bighas, there was some amicable partition amongst you and your brother. You say that you have got one land amongst many, which fell into patta number 147. Now, this patta number 147 contains 7 bighas, 1 katha, some lectures, 13 lectures or something, which contains 3 dags. Dag number 235, 236, 237. Dag number 235 contains 4 bighas, 4 katha, 4 lectures, which is the Suddag. Okay. Now, if that be so, you are asking for the entire land to be given back to you on the ground that the defendants have taken the possession.
Four
Okay.
bighas, 4 katha.
That is the entire Suddag.
Yeah.
The Suddag is 4 bighas, 4 katha, 4 lectures.
235.
That is 235. Meaning the dag number 235 contains no other land other than 4 bighas, 4 katha, 4 lectures. If that be so, how do you explain that in that very dag number, in the Jamabandi, more particularly the Chita of dag number 235, the name of Abdul Mujid is there. That is the predecessor in interest of the defendant.
That is, they want to say that exhibit Shaw.
Not only exhibit 4, that is your document, exhibit 4. Your document, you have exhibited exhibit 4. You take this document in a very carefully. मतलब कोई ना पाँव मैंने शीशे हो कुछ Kindly see this document. This is exhibit 4. That is your document. Now you see at serial number 4 of that document, which is, we have 3 dags. This is the Chita of dag number 100, patta number 147. We have 235 earlier. Not that big. Is that big? Yes. See,
235.
235.
Yes.
You have
4
Abdul
bigha,
Majid,
4 katha, 4 lectures. 249, 247. Number tag. Potta, Pokar, 247. Potta.
147.
147. 147. Yes.
And kindly see there,
Yes.
very clearly at serial number 4 is Abdul Majid.
Abdul Majid. Abdul Majid.
Abdul Majid happens to be them. So, can you therefore get a degree for the entire task?
Now, my lord, question is, this is a Ita. Hardship. If the defendant claims that this land belongs to Majid, their predecessor, so they have the land with them, they inherited it. In that case, they will have to substantiate it. Not on the basis of this they can claim.
No. They are not claiming on this. You are claiming on this. This
No,
is your document.
my claim is that my predecessor possessed it, and this Sheikh Hasim was my predecessor, and the other who were there, their predecessors are all there. We have denied totally that Hasim didn't sell anything, didn't transfer it. That. This is my case. And in that case, how could
his name came here.
Not
Abdul
only
Majid.
that,
Let us take it.
no, Mr. Mohta, kindly see down below. See the name in that particular thing, if tag number 235 is there, you have the names of Abdul Hai. I think serial number
Abdul
11
Hai,
or 12.
Abdul Hai, Ali, here, Abdul Hai, Abdul
Not 236, just before
Yusuf Ali.
236, before the line,
Yes.
the marketing line. Before that, you see Abdul Hai.
Oh.
Abdul Hai happens to be the son of
Pita Isab.
Isab Ali.
Isab Ali.
Now, Isab Ali, he has purchased it.
Isab Ali. Abdul Majid. Who is Majid? Majid then Abdul Pita Abid. Pita Abid. Abdul Pita Abid. Abdul Majid. He happens to be son of one Abid. He is son of one Abid. They are not 1, 2, 3. They are from one line. And he is from another line. Abdul Majid. Abdul Majid. Saharuddin Pita Majid. Saharuddin, yes. Pita Majid. Zahid Ali. Soed. Abdul Hamid. Abdul Abid comes from where?
Abdul Adid come from Sahad Ali.
Ali. After Zahid Ali is here. Pita Said. But Abid name is not here.
Hmm?
Abdul Majid, his father is Abid. Abid.
Abdul Majid's name is there.
Abdul Majid name is there.
Therefore, if Abdul Majid's name is there, can you get the suit, the possession in respect of the entire patta? And anti-dag?
I may have possession, but question of title, if comes, then what I find from the claim, my claim is that this land belongs to my predecessor.
But you have not disclosed that some land was sold, which is exhibit saw. I see exhibit saw from there. In that thing on
document is
down there later on. Be very careful. It is in a very bad state of it. It's a certified copy wherein 10 dogs have been sold, of which one dog happens to be dog number 97. No, it's just you have a certified copy also there. Next. Certified copy. Exhibit stock. It is your stock.
Electum Masim Sheikh. Masim Sheikh is my predecessor. Okay.
Your predecessor is Masam Sheikh. So Masam Sheikh has sold it in various dark, including dark number 97. From where you have dark number 36, 35, and 37.
Two 256, 253. But I got 235.
No doubt you may be entitled to some degree.
What I find is particular duck number is different here.
No, obviously, because this Damabandi which you are looking into, or that Chita,
Yes,
this is post 1968. Because at that point of time, it was dark number, pata number 42, which was called.
42.
This is the pata number 42, and various darks of pata number, which include pata number, dark number 97. And these, from these dark number 97, you have this 35, 36, maybe some fraction of land must have been down. But
97
don't you think this should have been litigated? I think the learned first appellate court went everywhere properly. Last moment, court could have taken into account how it is, because the moment after that, they immediately shifted the burden without looking into the Jamabandi or the Kita, wherein the name of Abdul Majid was there. Yes, the learned trial court or the first appellate court could have very well said that you are at best maybe not 4.5 bigas, but you are at least entitled to 3 bigas of area, and as such they had no right to it. And for which possession could have been very well given. But they put the burden upon them. Who wants the judgment? You want.
Well, they're taking the cue from your lordship, to be honest enough. if it is my case that they have sold out, my predecessor sold out some land from there, and leaving aside that land which was transferred, I still possess 4 bighas, 4 kathas, 4 acres land.
No. Your basic case is you have this entire 235 is yours. Your basic case is 235 is yours.
Yes.
Under no circumstance it could have been, they could have come and dispossessed.
Yeah, yes, that is my
That's
case.
your
Total.
basic case.
In that case, if they claim that no, we have meanwhile acquired some right or title over that by this means, then it is for them to accept.
Absolutely. There's no quarrel with that. But first, isn't it your burden to show that you are the exclusive owner of 235?
Yes.
Where is that?
Now,
From that exhibit 4 which you have done, that categorically shows that Abdul Majid's name is
in
there.
names appears, it cast a doubt. It cast a doubt. How come Majid's name appeared there? Explanation should have been there. And in that
And
case,
not only that, Mr. Monto, another big problem which I have seen,
kindly,
just now your junior had given me that document. Kindly see that document. See on the next page of that document, there is a person's name just on the right hand side of that portion which is there with the plastic out there. You will see out there a very interesting thing. In this doc number 235, somebody else's name has also entered.
Sohar Dr. Vikas Gitar 2000 15/5/2000 ইংৰাজী তাৰিখৰ খৰিদাৰ দখল সূত্ৰে পট্টাদাৰ চাহেদ আলীৰ লগত পট্টাৰ 235 236 দাগৰ অংশ একঠা এবিঘা 2 কঠা 16 লোচা মাটি মহম্মদ চহৰ আলীৰ পিতা সংসাৰ নেকি নামে নামজাৰি হয়.
Now the problem which arises thereafter is,
Yes.
this is prior to the filing of the suit.
Yes.
Now, if the decree is being passed, directing them to hand over the entire possession to you, what will happen to that person?
Another person will come here in meanwhile.
Another big problem.
Yeah.
So these are the things which have not been taken into consideration. And this was a document very much before.
This was not this, I suppose. This was not the document, but then Exhibit 4 is there.
Exhibit
was-
4,
this was
exhibit
not
4
there.
today, I don't know, your junior has just placed it before me
But
while
this is
hearing
not
it.
exhibited, I suppose.
Another big problem, now how can there be a decree passed
This was not this.
How can therefore be a decree passed by the learned trial court or the first appellate court without considering that something is there? Yes, very well. You may have a right of not against the defendant in respect to 3 bighas, 4 katha, 4 lechas. Even if we accept that that sale deed contains everything. But that was not considered. I think the best option is to remand Mr. Monto.
Yes, my lord. I
I
think
can't help it.
ultimately,
I
if this
tried
is
my
so-
best.
If
If
this
it
is so,
could have been
needs to be
resolved.
remanded.
It's a
Ultimately,
case of remand.
in that case,
Everywhere. You
That
see,
has to be
paragraph
looked
number
at.
11, the learned first appellate court went very beautifully. Dealt with every aspect of the matter. Now, paragraph number 12, paragraph number 11, the last portion at page 40.
Yes.
He did not discuss. He as if took it that on the basis of that deed, it is shown that the entire land is yours. Which is not.
apparently that document
No.
shows
He
someone else
only
is there.
discussed the exhibits of the defendant, nothing to do with the exhibit of the plaintiff, which is apparent.
How that name? But, if this, the defendants have not been able to prove, then the question is, my document, I owe an answer. I owe an answer. That to clear the doubt. Apparently, let the authority take the call. What people pointed out.
I think I payment additionally
They have to.
and take it before the first appellate court
Yes,
to decide on the basis of the document
Yeah.
as to whether the in view of reading of exhibit 4, read with the defendant exhibits 4.
this is
Is-
my document, their document is exhibit show.
And other documents we can say whether the defendant or any other person had any other right over this dark number 235
Any portion of land over there.
of dark number 35. Then the question would come up once he decides on those facts. Because this court could not be in a position to dare do that. It is very difficult.
It has to be decided on the basis of evidence again, if
No,
necessary.
these evidence,
Available
you are already having those evidence. So these evidence can be done if they can do it. But there is nothing out there.
Well, what I find, probably with these two.
Because I can't pass a decree. Here, if I say, I have to entirely nullify the entire.
Yes,
The decree is wrong. Couldn't have. And more particularly, this document which I've seen, which the junior
Yeah.
has to,
subsequent document. This is not a part
That
of the
document-
record, but it shows that
there's somebody
another
else.
person has also
Because
come in.
if a decree is being passed now, it will have serious consequences. They are in possession. You are going to throw him out and the court is going to deliver the possession. What will happen to those other persons? Again, another proceedings under order 21 rule 97. Then a first appeal. Then a second appeal. Let me come back. I'll
But then,
dictate the judge.
the fact remains that they are in the possession of the entire land. Therefore,
No, the fact remains they are in possession of the entire land, but the fact also remains that there is somebody else also who has a right over it which have not exercised.
well, that is again a question now has to be decided. Who is there? If really someone is there or somebody's name came for nothing, this has to be decided.
Because
by
on the
court below.
basis
If
of the
necessary,
evidence, can it be said, we can on the basis of the evidence, can it be said that the claim that the plaintiff is the absolute owner of 4 bigger 4 kata
for-
the entire dark number?
on the face of this, it is difficult to say that. So therefore now,
Then how much the plaintiff would be entitled?
yes, and who else, how much land he is entitled, and who, whether
No,
there are other.
we are not concerned how much. But if you
I-
are entitled to anything and he is in possession of something,
Yeah.
then obviously then the further question.
Yeah.
I'm coming back.
appellate court. What I find, that aspect Lordship can consider, if the learned appellate court has discussed about that some land was transferred. But what is the finding? Just kindly see. In the line about 16 from the top, page 39.
Hmm.
From exhibit top, Tia or to, what is the exact, Neo or to? There is no to, but maybe to or Neo. It reveals that Abdul Majid purchased the land from the son of Masim Sheikh. Masim Sheikh.
There is 236, 237.
Yes, this is another duck.
That is another thing.
This
We
is
are not
another duck.
concerned with. That is one kata, 5 lectures.
And an exhibit show, certified copy of the deed goes to show the defendant's predecessor, Abdul Majid, purchased 1 bigha land from Masim Sheikh, the predecessor of the plaintiff. But it reveals that this 1 bigha land is covered by different ducts. That is the finding.
That is it. It has different DAGs, of which one is DAG number 97. From 97, it became 235 and 236 and 237.
In
See, the
95,
problem
it was-
arises there. And
no,
therefore, in 235,
the certificate-
his name appears.
No. Well, if it was when it was 95, then it was purchased.
Hmm.
That tell deed
Hmm.
related to the period when the land was covered by Duct 95,
97.
97.
Ah.
Subsequently, it became
235, 236, 237.
process
Therefore,
from
his
97
name
itself.
appears there. So, therefore,
Then
that is why I'm saying paragraph number 11, properly it has taken. Last moment, the court did not consider that aspect of the matter. That how, because the burden is yours.
exhibit cost shows that the land was purchased in Chutpatta, but tag number 97. Tag number 97. Dorothy has just mentioned about 97.
Hmm.
That time, 97. Post 97. From exhibit Ungo, it also reveals that the land is covered by different ducts of Chutpatta. It reveals from the record that the present suit land of the plaintiff and other lands were covered by old Patta number 42 of 1930-31 settlement. And in the state Patta, there
And
was
Mr.
34
Mohanta,
My
before reading that, you can read this paragraph 11,
Yes.
first portion, 4 lines, 5 lines from the top. The new dark numbers. You read it?
Yes. The new DAG numbers 235, 236, 237 are part of old DAG number 97. Yes. From the very
Therefore, the problem arises there. Maybe a portion of it somewhere. But can you get the right title interest for entire thing?
so 97 ultimately became 235, 236, 237. And my purchase is 235. My claim is on 235.
Right.
Then apprehension may be the 235 may also contain
To the
some
part
portion
of it.
of that.
That is why his name is there. So therefore, it has to be clearly found out that dark number 236, 237 and all other darks ought to have taken, or the portion of the lands held in dark number 97 was purely in 236 and 237, nothing to do with dark number 235.
That clear finding has to be recorded.
Ah.
And for that, some exercise is required to be taken. If necessary, by oral evidence as well, also may be necessary for some commission to find out. Some commission may be
Well, let me write it down. The instant appeal has been prepared under section 100 of the Code of Civil Procedure 1908, for short the code. challenging the judgment and decree dated 22/11/2011, passed by the Learned Court of the Additional District Judge, Nagaon, Assam, bracketed, for short, the First Appellate Court, bracket close, full stop. By an order dated 19/3/2013, the instant appeal was admitted by formulating the following substantial question of law: whether the learned court below committed perversity in interpreting the defendant's purchase deeds, viz. Exhibit Gh to Exhibit Tau, and overlooking the evidence of DW1 vis-a-vis the mutation in the name of the plaintiff while declaring right, title, and interest of the suit land in favor of the plaintiff. For the purpose of deciding as to whether the said substantial question of law is involved in the instant appeal, this court finds it relevant to take note of the facts in brief, infra. Follow. The plaintiffs are the successor in interest of one Masim Sheikh, bracket, since deceased. It is the specific case of the plaintiff that they are the owners of DAG number 235 of periodic patta number 147, which covers an area of 4 bighas, 4 katha, 4 lechas, situated at Kisam, Kadumguri, Moza, Hanagora, Hangagorah, in the district of Nagaon. The said land, for the sake of convenience, is hereinafter referred to as the suit land. It has been the specific case of the plaintiffs in the plaint that they were the absolute owners of the said suit land. However, the defendants had denied their title on various dates and trespassed into the suit land on 23/3/2001. It is under such circumstances the suit was filed seeking right title and interest of the plaintiffs over the suit land with a decree for recovery of thus possession against the defendants, semicolon. A decree for demolition of any house structure on the suit land erected by the defendants during the pendency of the suit, if any, by putting the plaintiffs into vacant possession of the same by removing those houses, oblique structures, etc. from the suit land with men and material for permanent injunction, semicolon, for permanent injunction, comma, cost of the suit, etc. On the basis of the suit being filed, which was registered and numbered as title suit number 5/01, the defendant numbers 1 to 5 filed their written statement claiming inter alia that 7 acres 1 kata 18 lectures of land is covered by DAG number 235, 236, 237. Which is a part of the old DAG number 97 of periodic patta number 42 of 1930-31 settlement. This very patta, being periodic patta number 42, originally contained 9 DAGs and had land admeasuring 34 bighas, 1 katha, 18 lectures. It was mentioned that on 29/3/1952, one Abdul Subhan, Subhan, sold 3 bighas, 3 katha, 15 lectures of land covered by DAG number 97 to one Abdul Majid, since deceased, by the registered sale deed. Full stop. Further to that, on 21/1/1944, the Said Abdul Suhan sold another 2 bighas, 2 katha, 5 lectures of land to one Isab Ali, who subsequently on 2/3/1945 sold the said land to Abdul Majid. Further to that, the predecessor in interest of the plaintiff, one the late Masam Sheikh, by the deed of sale dated 22/1/1962 sold a portion of the land covered by Dag number 97. Sold a portion of the land, sold 1 biga of land, which included a portion of the land of Dag number 97. It was also stated that one of the sons of Masamse, late Masamse, by the registered sale deed number 3076 dated 8/3/1972, sold 1 katha 5 letters of land to late Abdul Majid from Dag number 236 and 237. It was, however, mentioned that from a perusal of the said boundaries mentioned in the said deed of sale, it would show that the delivery of possession was made in respect of Dag number 235. It was therefore the specific case of the defendants in the written statement that late Masamse had no land in Dag number 235 of PP Patta number 147. And as such, the suit which was filed ought to be dismissed as it was false and vexatious. On the basis of the said pleadings, the learned trial court framed as many as 8 issues which included the issue as to whether the plaintiff had right, title, and interest over the suit land, and whether they were entitled to get khas possession thereof, which was issue number 3. The learned trial court, after taking into account the evidence on record, came to a finding that the plaintiff had right, title, and interest over the suit land, and the defendants dispossessed the plaintiff, and as such, the plaintiffs were entitled to recovery of khas possession. The other issues were also decided in favor of the plaintiff. Resultantly, by the judgment and decree dated 14/8/2006, the learned trial court decreed the suit of the plaintiff with cost, declaring the right, title, and interest of the plaintiff over the suit land, and further decreed for recovery of khas possession against the defendants by demolishing any house structure on the suit land erected by the defendants during the pendency of the suit. Further to that, the learned trial court directed that the plaintiff be put into vacant possession of the suit land by removing men, materials of those structures, and a permanent injunction was also granted against the defendants, prohibiting them from erecting any house structure over the suit land. The defendants, being aggrieved, preferred an appeal before the court of the district judge, Nagaon, which was endorsed to the court of the additional district judge, Nagaon, for disposal. The said appeal was registered and numbered as title appeal number 25 N/2006. The learned First Appellate Court decided the said appeal issue-wise In deciding the issue number 3, the learned trial court, first appellate court, came to a finding that the plaintiff were entitled to a judge decree for right title and interest over the suit land, as well as for recovery of cast possession, including the other reliefs which were given by the trial court. Under such circumstances, the said judgment and decree was passed on 22/11/2011. And under such circumstances, being agreed, the instant second appeal has been filed. Taking into account the issues involved, the substantial question of law which have been framed, this court have duly heard Mr. B.C. Das, the learned senior counsel, assisted by so-and-so, and Mr. K.K. Mohanto, appearing for the appellant, and Mr. K.K. Mohanto, the learned senior counsel, assisted by so-and-so. The substantial question of law which have been framed in effect relates to as to whether there is any perversity in the findings arrived at on the interpretation of the exhibited documents of the defendants and the evidence adduced by the defendant number 1 vis-a-vis the mutation of the plaintiff. This court finds it very relevant to take note of. Now, that amongst the various exhibited documents by the defendants, to show their title over the land, Exhibit Shaw is a deed of sale dated 22/1/1962, whereby the defendant, whereby the predecessor in interest of the plaintiff have sold 1 bigha of land to the defendant, to the predecessor in interest of the defendant. The said land was covered by DAG number 106, 251, 252, 256, 101, 260, 253, oblique 97, oblique 103, which was a part of the total land measuring 34 bigha, 1 katha, 18 lechas of Pata number 42. From the materials on record, more particularly the evidence which have been discussed by the learned first appellate court, it transpired that the old Patta number 42 of the 1930-31 settlement contained a total land of 34 bighas, 1 katha, 18 lechas in 9 darks. There is no denial to the fact that this Dagda Patta number 42 belonged to the father of the plaintiff, belonged to the father of the plaintiffs, late Masam Sheikh, and Samser Ali Hukai belong to whom? Somewhere it is given. Belong to the father of the plaintiff, late Masam Sheikh, and his brothers.
His brother, 6 to 9 defendants.
Hmm?
6 to 9 defendants,
And his
Yeah.
brothers.
their predecessors.
However, it is further seen from paragraph number 11 of the judgment of the First Appellate Court, which is based upon evidence that the new DAG 235, that out of DAG number, Patta number 42, a new Patta was made, that is Patta number 147. Further to that, the new DAG numbers 235, 236, and 237 were the part of old DAG number 97. It is further seen from the judgment itself that DAG number 235 contains 4 bighas, 4 katha, 4 lechas, and the remaining 2 bighas, 2 katha, 14 lechas is covered by DAG number 236 and 237. This court further finds it relevant to take note of that the learned First Appellate Court, while deciding the said appeal, duly had taken note of Exhibit Shaw, and decided and came to an opinion that from the said Exhibit Shaw, it revealed that late Masam Sheikh sold 1 bigha of land to late Abdul Majid in various DAGs, which included DAG number 97. The learned First Appellate Court thereafter did not take into consideration as to whether the said land which was sold to late Abdul Majid by the deed of sale dated 22/1/1962 contained any plot of any portion of the land which fell in DAG number 235. This court have also taken note of Exhibit 4, which was a document exhibited by the plaintiff. This Exhibit 4 categorically is the cheetah of Pata number 147, showing the dark number 235, 236, and 237. From a perusal of the said Exhibit 4, it is said that the name of Abdul Mujid is also seen in respect to dark number 235 of Pata number 147. The question therefore arises as to whether the plaintiff would be entitled to the declaration of right, title, and interest in respect of the entire suitland, which comprises of 4 bighas, 4 katha, 4 lechas in dark number 235. More so, taking into consideration that the said Exhibit 4, which is the document exhibited by the plaintiff, also shows that not only the name of the plaintiffs are there, but also the name of various other persons are also mentioned in the said document. This aspect, this court further finds it relevant to take note of that when it is the plaintiff who is seeking for a judgment in its favor, the provisions of Section 101 of the Indian Evidence Act 1872 would show that it is the burden lies upon the plaintiff to show that the plaintiff has exclusive and absolute right over dark number 235 or Pata number 147, which, however, have not been taken into consideration by the learned trial court, either by the learned trial court or by the learned first appellate court. Both the courts below have taken into consideration on the basis that the defendant have failed to prove that they had any right over dark number 235, but did not take into consideration as to whether the plaintiff have been able to prove as to whether the plaintiff had the absolute and exclusive right over dark number 235 or Pata number 147. Under such circumstances, this court, taking into account the evidence on record, is of the opinion that this is a fit case for remand to the first appellate court, taking into account that this vital aspect of the matter have been totally disregarded by the learned first appellate court. Considering this court, further, in exercise of its powers under Order 41, Rule 2325 of the Code of Civil Procedure 1908, is also of the opinion that an additional issue requires to be framed in the instant proceedings. Accordingly, the issue so framed is as hereinafter: whether from the materials on record, whether the plaintiff have been able to show their exclusive and absolute right over the suitland on the basis of the have been able to show their exclusive and absolute right over the suitland on the basis of the evidence on record. I think that is enough. This court, however, while remanding the instant appeal, remanding directs the learned trial court, learned first appellate court, to decide the said issue, along with which would have a further bearing on the decision in respect of issue number 3, and as such may permit both the parties to adduce evidence, if any, if they desire so, and also may, if required, take necessary evidence from the revenue authorities. With the above, the instant appeal therefore stands disposed of, thereby directing the learned first appellate court to decide afresh the appeal on the basis of the issue so framed, on the basis of the above issues, so additional issues so framed, and thereupon decide the same in accordance with law. The registry is directed to forthwith transmit the records back to the learned first appellate court so that the same is taken up for disposal at the earliest.
Judgment and decree, update decree.
This court, further taking into account the above, sets aside the judgment and decree passed by the learned, the impugned judgment and decree dated so and so, passed by the learned first appellate court. This case is closed.
Yes,
That is judgment dated on 21st December.
yes.
2011. 21st December, lordship must have said 22, maybe 21st December.
Let's see. Record.
Ah.
Record.
Page 41, 22.
It would be the 21st December, 35. We can have a question.
We are not fine.
21.
Yes, 21.
21, huh? 21, 11, 2000.
11 and 12.
2011.
2011.
Well, it is 12 has been given, my lord. Two
Huh?
dates. In the dictated and corrected on 20.
Don't worry, all these things will be correct.
Yes,
At last, some
Yes, sir.
2012 matters.
this has gone. Long pending matters. Deeply applied.
Eh?
Deeply applied that.
Same one time being.
My lord, in this case, I have received some instruction regarding the 7A and 7.2, my lord.
What do you say at number 3? Serial number 3.
It is, my lord, applicable, my lord, if there is a no fault, my lord, circular.
No, kindly see. Number 3. Further, as per point number 8, page 4, in case of third party breaches, as in this case, where the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system. Table 2 clearly strengthens our argument that for within 4 to 7 days of reporting of the fraudulent transaction, the per transaction liability of the customer shall be limited to the transaction value or the amount mentioned in table 1, whichever is lower, that is rupees 10,000. Meaning, isn't it very clear that you are accepting it?
No, my lord, that rule, my lord, the petitioner, my lord, additional affidavit circular, my lord, for a
No, understood.
Yeah.
What do you mean by number 3? Are you not admitting it?
not admitting, but my lord, here is a case, my lord, that they say that, my lord, even my lord, this thing happened, then according to RBI, it is that 10,000 is entitled. But this case is a para point 8 is not applicable in this particular case. My
You are saying that para 8 category A would not applicable.
my
Are
lord,
you
for a
saying?
moment, the circular, my lord.
Kindly see further as per point number 8, page 4, in the case of third party breaches, as in this case.
My lord, for a moment, kindly look into that original circular, my lord, 17 circular, page 61 is the rank.
Yes.
Overall liability, may I read, my lord? Overall liability of the customer in the third party breaches, the details of paragraph 6.2 and paragraph 7.2 in the above, where the deficiency lies neither with the bank nor the customer. Here is a petitioner, my lord, himself, my lord, compromised that pins, my lord. So, and OTP also delivered, my lord.
No, it mentioned in the RBI thing.
Yes, my lord.
No, 7-1 will be when?
7.2, my lord.
No, kindly come to, you say that you come under, the petitioner comes under 7-1.
Yes, lord.
What is your basis why the petitioner comes? Is it where he has shared the payment credential? That is only the petitioner would be fault. Has the petitioner out here shared the credential? No,
Yes, my lord.
no, he has not done that. He has been defrauded by the Airtel as well as all the other things.
No, my lord. Without, my lord, in sharing that pin, my lord, that it is not possible to the fraudster, my lord. He compromises everything, my lord. To
How
the
did he
and,
compromise?
my
He
lord, my,
never compromised. The moment you asked him to file an FIR, he filed an FIR. The investigation categorically shows that yes, the petitioner have been taken for a ride, which is very clear from the investigation. It's all because of the fault of the Airtel. That's a different thing. I'll give you the liberty to initiate proceedings against the Airtel. We'll impose the Airtel with liability out here for the cost of the litigation.
but my lord, he compromised. But there is a third party transaction was happened.
He
My
never
lord, only
compromised.
because- But my lord,
Are you saying that the petitioner have provided the details?
yes,
No.
my lord, my paragraph, my reply, I have categorically stated in page 3 of my reply 7, my lord, paragraph 7, my lord, where we have categorically stated that the answering respondent, my lord, petitioner has compromised his secret EPI pin to the fraudster. OTP is not required to EPI transaction, but only the secret pin is required to logging into the EPI apps, my lord. In my our reply, I have categorically stated, my lord. And my lord, the message, my lord, the SMS the report also I have as a annexer B, my lord, in my our bank reply, my lord. Now, my lord, he compromised, my lord, and if compromised, my lord, customer is compromise is everything. Then, my lord, is
He never compromised. His mobile phone was black.
my lord, without compromise, my lord, it's not possible to, my lord, that internet banking and my lord, 9 internet banking was happened, my lord, in this case, and T was EPI, my lord. Internet banking and my EPI transaction can be only happen if, my lord, petitioner is not compromised the secret pin and my lord RMS my lord, then it is not
What
possible.
secret?
Is my lord. UPI pin
OTP.
number. Yes, my lord.
OTP you have given.
OTP is not required for the UPI transaction, my lord. Only my lord, a PIN is required, my lord. OTP is not required. But the internet banking OTP is required, my lord. OTP was delivered, my lord. That copy I have another.
No, UPI, there is no problem with the UPI. How much is the amount which has gone in UPI? All was done through internet.
My lord, 9 transaction was happened, my lord, for internet banking, my
No,
lord.
internet only, we are concerned. We are not concerned with others.
My lord, then my lord, according to this, my lord, the Airtel can explain, my lord. Their report I have finished, my lord. Everything is delivered, my lord. OTP was,
Where is the bank statement?
my lord, here is there, my lord.
Page 45 I have given.
Page 4, my lord.
These are all internet bank.
And my lord, page 4 of our reply, my lord.
Where is
Page
the bank
45
statement?
of the writ
This is withdrawal transfer, withdrawal transfer, withdrawal transfer,
internet
Then-
banking. These are all internet.
withdrawal bank. These are all internet bank.
Only
Yes, my
there is
lord.
one UPI, your lordship, the first one.
Which one?
This is withdrawal transfer that is written as UPI. The rest are digital
Where is
banking,
the
internet
UPI?
banking,
This
internet.
year back. That is 5,000.
That is 5,000, rest are all internet.
We are not
No,
concerned with.
UPI there is a 3, my lord. One is 5,000, another 2 is 50,000, 50,000, my
Where?
malformed. In my reply, I have categorically stated, my lord.
This statement does not show so.
That statement, my lord, paragraph 4.
You
My
are
lord,
saying that
for
your
a- for a
statement is
moment, my
wrong.
lord. Which one, my lord? In my page 8, my lord.
Oh,
Page 8 of our reply, my lord. Bank reply, my lord.
yeah.
Then, my lord, 3 on third, my lord, 2 figure is there, 50,000 and 50,000. So this why, my lord, would help you.
Where? Page
Page internet page
8.
page 46, my lord.
When?
Third, my lord.
Third, these are all not UPI. These are not UPI.
2 transaction was there.
No.
50,000,
UPI
50,000.
is at page number 7. Kindly see 210. 210 is a UPI of 5,000.
3 types of there, my lord.
No,
INB, my lord, internet banking, my lord.
you made the ATM cash withdrawal of 20,000. Mr. Manan,
Yes, my lord.
you made that ATM cash withdrawal on third 20,000.
That was made by the petition.
Petition.
First one by petition. Then thereafter the whole amount has been.
And these are all withdrawals, digital banking.
On third, my lord, there is a internet banking withdrawal, my
And
lord.
what is this 17,966?
15,966 is also your lordship not by the
Why the specific amount of 17,966? There must be some reason.
My lord, what happened, my lord? All transaction was, my lord, corporate transaction was, my lord.
Hmm?
There's some, my lord, Pudostar, my lord, what you my lord, you purchase some goods, my lord, from the corporate account, my lord. That is why that problem is there. This is a corporate account, which that money was transferred, my lord. So it is not possible that find out that if the money is transferred to corporate account. And the Pudostar have purchased something, my lord, from this corporate account. This is the thing, my
No, the only worry, I'm not on that. To impose you, there's no problem with that. But how do you bring the Airtel into the... See, the problem arose because of the... See, the petitioner is a pensioner.
I
There's no quarrel. The petitioner didn't do it. The petitioner did no... How do I entangle the Airtel? That is my only thing. Otherwise, Airtel problem was not there. I would have, in the meantime, I have delivered the judgment long time. Only problem is how do I entangle the Airtel?
OTP, my lord, is there, my lord. OTP, my lord, internet banking.
No,
OTP
they
is
had made the mistake.
I
They,
have,
without proper verification, they have allowed the scheme,
yes, my
which they could not have given.
I have annexed the circular of with the government of the Department of Telecommunication that I have annexed in the affidavit
Show
where
me
it
that
has stated
something can be done against Airtel.
that part your lordship find in the affidavit against the my affidavit
Against
against the respondent number 10 in the page
Where is the circular?
external page 78 page
Very difficult.
after the my affidavit, the affidavit against them.
Instruction for using new. This is the government of India.
Yes, this is the
The
government of
original
India.
subscribers
2
that
and 3 your
submit the
lordship will
proof of identity, document at the point of sale of
Yes.
license and record the reasons of SIM replacement along with
This
his
was
or
not done
her
correctly.
signature and date. The person at the POS shall match the copy of the POI document
This is not
submitted
done.
by the subscriber with the original and also record a declaration on it along with his or her name, date, POS code, and POS stamp containing address that has been in the subscriber and match the copy of the POI document with it. Only after this activity, new SIM card may be issued to the subscriber.
And 2, 3 also.
Before activating the new SIM card, the employer of the license who is activating the RIA shall verify that the details of the POI document submitted by the subscriber matching with the records available with the licensee and also record a declaration to this effect on the copy of the POI document with under his or her POI. Now let us see the affidavit filed by Airtel. What do they say?
Airtel, the earlier affidavit, they've annexed these documents, which were submitted by the fraudster as well as our original document. Earlier. That will be
Got it. Got it. Affidavit on behalf of respondent number 10 in
here, annexure A.
Hmm?
Annexure A is the original your lordship document submitted by me.
which one?
The
No,
there were
no,
two
the
affidavits
problem,
filed
Mr. Manan, the problem, do you know what the right is? You don't mark it. Nowadays, we don't have that number. That number is stuck off. We are having only a running page. That is why it becomes a big problem.
Yes, actually this is the running page given by them.
Not by them. The running page is how much?
Here it is stated as 61.
61. No.
But I don't think it is 80.
Oh, I think both of you need to do it.
Because
This is some affidavit filed by respondent number 1, 10 and 11. Wait. On 22nd of November 2023.
just the
Yes. Airtel prepaid.
24, yes. Here page annexure 1 your lordship.
Annexure A series.
Yes.
Yes. What does it
Here
say?
this is the original one.
Ah.
This is the photograph. Date of birth lordship kindly 11/4/1990.
Where?
That is just name customer.
11/4/1990.
Yes. Now your lordship, the second document that was produced by the
Student's identity card.
yes, I card also name, the address, other's name, and the date of birth.
Hmm.
Now your lordship turn to the next page is the connector. Then your lordship will see fraud one. The photograph is different. Then your lordship will see the date of birth. 1185. Third next. 1180 is the date of birth. Tulika Dekas, here it is gender is shown as male and the father's name has
And
been
what is the document they have given? They
I
must
have
have
given
given
one
some
document
document.
that is the next page. Next page, that is, I think, the election electro photo identity. Next. Here, your lordship, this has not been clearly verified.
28 years.
Here it is.
Village Hiragota. T.S. Rongia.
Yes.
Is the address of this person. Village Para. Pure Rongia. Rongia Murara. This is different village.
These two.
Hiragota LP School. Part 1. Hiragota LP School.
Yes. This was given by the process. And the earlier one was with regard the school certificate and the form. These are two different addresses. This was not verified. Correct. At least the date of birth. Addresses may be different. I'm not saying, but the date of birth cannot be different. To that point, these are another thing. Photos and all. I'm not saying anything.
Photo same.
Photo different. Photo is different.
Don't understand how can these people give a year of this was student's identity card class 1 when first class first.
This is a higher secondary school, so first year of the
Art.
yes, first year art.
So this term must have been given in 2007. On top it is in 2007. So she
Yes,
was 17 years
2007.
then.
It was 11/4/9.
17 years then.
Then
Now here, this form was submitted when?
form was submitted, your lordship. Seam swap submitted date is 1/10/2020.
Huh? No. This form, first form.
First form was submitted
11/11/2008. And
11,
then
11,
she was 17. And here she is 2013. This was given 2013. She's 28 years.
The
How is it possible?
no, it has been shown as 1185.
Uh,
So 1185 is not her birthday, and this photograph is also not her. So that was which was incorrect, your lord. Then just below the date of birth also, the SIM swap submission was done on 1/10/2020.
the copy of the proof of So they did not match it with the date of birth.
Yes. According to the circular of the DOT. They should have done that. It says very clearly.
And has the police tried to find out this lady whose name is shown out here?
That police report has said that these they were all male people who were arrested, male person, and they have one of the fraudster. This fake I-card was
This fake,
this fake one, which was submitted before the Airtel. That was in
This-
the affidavit.
this is fake, they say.
Yes, the police said that is fake. So they have given a fake electoral I-card before the Airtel, and Airtel accepted it. So they did not verify that fake one with the original date of birth. Anyway, they may not be able to distinguish the fake or the, but the date of birth was wrong. The address was different. They did not verify, and did not even, it was as per the circular of the Department of Telecommunications. They are supposed
They
to
should have at least seen
Yeah.
the date of birth along with the earlier, and this is different.
different. That's good enough. The photographs, I understand they are saying in their affidavit that this was issued 12 years back. Now the person's face must have changed. Okay, that's believable. But what about the date of birth? That cannot. So that is the part which they have the Airtel at the POI center have not done as per the its DOT side. That is that. And the second part, your lordship, the SBI has. I'm not blaming them, but the liability is there. That's all. But they cannot point the liability. Yes.
Yes, Mr. Roy, you-
So far, date of birth is concerned, my lord. In fact, when on 4/10 they went there, they got a new
Huh?
SIM. They got a new SIM on 4/10. Now, lordship will see that at page 67.
Hmm.
My learned friend has not pointed out to that.
Yeah.
Your lordship see 4/10/2020.
Ah.
There, the date of birth is 4/10/1998, which the petitioner himself has.
This is another one.
Yes, because this is the when his SIM was blocked. After that, she went on 4/10 to get a new SIM, where she has declared her date of birth as 4/10/1998.
Then?
So there is mismatch of date of birth everywhere, my lord.
No. Then these two persons' faces are different.
No,
No, kindly come over page 64 and 67.
yes, I'm coming. 64.
One has
No, 64 is the fraud, my lord.
Huh?
Fraud. So by fraud, they have taken out this, given this proof of identity to the that point of sale. There, they got this document, page 64. There, the date of birth has been shown as
So did you issue the SIM card on the basis of 64?
no. When she complained that her mobile has been blocked on 4/10, that lordship may see that document at page 67, 4/10, 2020, 10:52, 42 seconds. They went there, and there she had declared her date of birth is 4/10/1998. So date of birth is not mandatory, my lord. Lordship is the guideline. Date of birth is only the proof of identity. He gives it, and it will be matched with the original, which the fraudster has given the fraud, that is original certificate or original voter ID. So that is mismatch, my lord.
No, but the original voter ID on the face of it was mismatching with your document.
No, that's what, my lord. Date of birth is not material, my lord.
Why do you say the date of birth is not
No,
material?
lordship sees the guidelines.
Where?
Yes, is that page 78.
Page?
78, man. That is DOT guideline, which we are bound to follow.
78.
8, man.
Yes.
The original subscriber shall submit a proof of identity POI document, point of sale of licensee, and record the reasons of SIM replacement along with her name, signature on the date of the same. So this document, lordship may counter 64 page may be seen. She has given
Now,
proof
why
of-
you say that date of birth is not necessary?
That is not necessary.
What is your basis to say?
It's a PO, that is proof of identity document is required.
Understood, but you have to match the proof of identity document with the others. Kindly see
Yes,
the
others.
next paragraph. The person at
The
point
wo-
of sale
Lordship will see one thing.
shall match the copy of the proof of identity document submitted by the subscriber with the original.
Yes.
Okay. And also record a declaration on it along with his or her name, signature, date,
Date.
proof of point of sale code,
Yes.
point of sale stamp containing address that he has seen the subscriber and match the copy of the point of match the copy of the proof of
Proof of
identity document with its original.
origin.
Okay. Only after this activity, new SIM card can be issued.
Yes.
Then next see.
Yes.
Before activating of the new SIM card, the
Yeah.
employee of the licensee who is activating the year shall verify that the details of the proof of identity document submitted by the subscriber are matching with the records available with the licensee.
Yes.
Where?
So
The records which are available with the licensee has a different date of birth.
no, but the Lordship will see that name and photo is same.
So what?
Because
The photo is not the same.
no photo they have found to be resembling with the, because the school photography Lordship see. Because
I'm not concerned with that. But if the photograph or anything is different, if you the moment there is two different photographs, are you not supposed to look into the date of birth?
correct, my lord. But this document does not say date of birth, proof of identity.
Not
that-
necessary.
this voter list.
Kindly see. Verify that the details of what is details?
Details, date of birth, father's
You
name.
want, for your
No,
goodness,
father's
you
name.
want that the details should be the photograph
No,
and not the
photograph, father's
when it is
name,
not convenient
father's
to you.
name, address, my lord, that will be seen. Now, Lordship, you will see, Lordship will see that when they applied for new SIM, that is when the SIM was blocked, and then when she went, that is page 67 document, my lord, where she herself given her date of birth is wrong, 98.
How do you know?
That is there on the record. That's what I'm showing.
You
my
have
lord.
recorded.
No, that is there. They given
When they
the
went
record.
to give a complaint, you must have manipulated it.
No, Lord, we have produced the document.
No, you have the moment you find out that yes, we are in trouble, we'll do everything.
No,
Yes.
Lordship
is
will
what you
see
have
these are
done.
the document which has been
No, tell me whether the subscriber has in any manner the power to make this entry 4/10/1988 or 98. No, it is you who have done it.
no, but upon their
Later
declaration, my
on to
lord,
come up and make
No,
it a
no.
defense.
that means it can be otherwise also, my lord. That's why the date of birth she has declared that point of time when she went there on 4/10/2020 as 4/10/98, my lord.
Hmm?
That is one she went there herself. And this is digitalized, my lord.
Hmm?
This document has been digitalized.
Digitalize, no problem with it. Digitalize is all in your hand. Now, Mr. from SBI, tell me, when were these transactions of 410 taken out? There's a transaction of 1 lakh or 10 lakh. 1 lakh and 1 lakh, 2 lakhs, no? 2 lakhs and 60,000. 2 lakh 60,000 taken up. 2 lakh 60,000, 2 lakh 62,000. Now, these happen at what time? Understood. What time?
Timing is not there.
Timing they will get. They can get it.
Yes,
No
they can get.
What is the time? Because here, you see, the person concerned went to you at 10:52. Team web submitted on 4/10/2020, 10:52. This must have been done at night.
From our reply,
And what is this? What is the document she has submitted then?
Again, voter ID, my lord.
Which one?
That is page 69, my lord.
Huh?
Page 69.
You see the address Muraria, and the earlier address was different. Kindly see this page. Kindly see this document. Kindly page 62. What is the address given? Address Rongia Murara. Okay. Then you kindly see the document on which you believe.
Yes.
Village, town, Hiragota. Page 65. And then the actual document here is also shows village Murara.
My lord will see that voter ID card, he went to that for change of name, my lord. So this is basically, my lord, the address can be changed, maybe changed, my lord.
No, you could not have done that. When there are two things out there, you need to do something. You couldn't have done that.
Now, lordship, last night I've seen that FIR. Lordship may see that FIR copy, my lord, for a moment, my lord. At page 26 of the writ, my lord. Page 26 of the writ, the FIR may be seen, my lord, for more.
Page
26, my lord. I'll read carefully, my lord, this FIR.
Yeah.
With due respect, I am to inform you that on 2/10/20, I withdrawn an amount of rupees 9,500 by using ATM card, and thereafter I haven't withdrawn any amount. But thereafter on 9/10/2020, when I went to withdraw money, it was reported to be insufficient fund prior to that on 2/10/2010. Now this is important. I was informed over phone that I shall be gaining an amount under PLI on 2020 when I recharged my phone till 4/10/20. No phone calls were received by me since 2/10/20, an amount of which so returned. Now, I was informed on 2/10/20, I was informed over phone that I shall be gaining an amount under PLI. I've seen that PLI should be the postal life
Let us
insurance.
read the estimates one.
Yes,
Yeah, better.
Yes.
Let us not go into this complication of allowing Mr. Yusuf Manan's translation of believing. Yes,
So
read it.
I asked my friend to read it.
মোৰ বিনীত নিবেদন এই যে মোৰ একাউণ্টৰ পৰা 2/10/2020 তাৰিখে 9,500 টকা এটিএমৰ পৰা উলিয়াই তাৰ পিছত মই মোৰ একাউণ্টৰ পৰা কোনো ধৰণৰ টকা উলিওৱা নাই, কিন্তু 9/10/2020 তাৰিখে টকা উলিয়াবলৈ গৈ মই দেখা পালো যে মোৰ একাউণ্টত কোনো টকা নাই। ইয়াৰ আগতে 2/10/2020 তাৰিখে মোৰ মোবাইল নম্বৰত PLI কিবা পইচা পাম বুলি ফোন আহিছিল। 2/10/2020 তাৰিখে মই ৰিচাৰ্জ কৰাৰ পিছত 4/10/2020 তাৰিখলৈ কোনো ধৰণৰ ফোন অহা নাছিল।
And then
2/10/2020 লৈ মোৰ একাউণ্টৰ পৰা 9,13,506.54 টকা উলিয়াই লৈ গৈছে।
Then what is wrong with that?
That is that I feel that, my lord. He says that PLI is a should be, my lord, postal life insurance. So he had compromised his, my lord, PIN number thereby.
Where?
Because this he said that that he's gained by that. That I have more account. I was informed over phone that I shall be gaining an amount under PLI. Maybe, my lord. Thereafter, lordship may see.
Mr. Roy, this type of fantasy, even in Hindi movies, we don't see.
No. Lordship say,
That is too much.
Lordship,
Your lordship,
Lord-
there is the report of
He
the
may
police. Kindly
think
see the
you-
report of the
you-
police next page.
no,
Huh?
Lordship may come to page 45, my lord. Page 45, my lord. The account. On 3/10/20, there is a ATM. It was nobody has whispered about that 20,000 because after withdrawing 9,500, he said his account was completely blocked. But there is a withdrawal ATM through ATM 20,000 rupees, my lord, and that has been withdrawn from Nagaon branch, my lord. So how come that can be withdrawn, my lord? ATM. Because your lordship see
When did you issue the
410, my
Huh?
no, the first,
First of
110, my
110.
lord. 110.
Team was on
and
110.
when did they apply?
They applied on
They applied
110, it was given on 110.
And what time?
And 110, there 48 hours, there will be a, they have stated that
Blockage
it
of
will
it.
be blocked. So 40 hours, there was no transaction. So on third transaction,
Yes.
so the 48 hours, this is,
So ATM, my lord, let's three account under that is one is withdrawal from ATM and UPI and internet banking. Three more they have accepted. Now, if you withdraw from ATM, now what is requirement? Physical debit card along with PIN, 4-digit PIN he has to give. That 4-digit PIN he only knows, my lord. Nobody else can be knowing, my lord. So unless he compromise with the PIN, he cannot withdraw from the ATM card, my lord.
That is not necessary. We are not concerned with those amounts. We are only concerned with the remaining amount. It all
Right.
happened because
My
of
lord,
you.
then UPI, my lord, UPI, my lord, debit card.
Forget
details.
about UPI. We are not concerned. We
The
are
internet
concerned
banking, my lord.
after. We are concerned with 310 the withdrawal transfers from which have been made. This is SBI Live.
Hmm.
There is some
No.
withdrawal transfer of I think, oh, this is a transfer. That is why I am saying 17 lakhs 96,000. Some SBI Live.
17,900.
That is some
17,966.
withdraw. That is a SBI Life insurance or
okay,
something.
so it has must
So
have
this
been
is that is why.
debited,
That is it is automatically debited.
automatic. That
And
is why-
remaining are all these things.
because that amount is not shown in the your lordship, the when the product amount.
Right. Now, so far internet banking is concerned, my lord, he has to have the processor has to have account number, customer identification file number, debit card details, debit card PIN, branch code, and registered mobile. So this much one is required to have internet banking. So without that, it is not possible. Through SIM swap, this amount can be taken.
No, Mr. Roy, these are not this question. Question is how much. The question is there is a mistake, not a mistake. A blunder has been committed by Airtel. The Airtel has to do something. Now, how much should this court impose upon you and how much? That is the. We may direct the SBI to pay the amount and direct you to pay 50% to this. That might be the case. But the question is how much something has to be given against you because there has been a carelessness. And if I don't give anything out there, that will result tomorrow and making the Airtel or all SIM subscribers go scot-free.
Lordship, see my reply, my lord, which
No, your reply on all these things makes it very clear. In fact, you have yourself admitted.
that, but the daughter is not daughter is not before the court, but he is a subscriber of that mobile number, my lord. So she is not before the court, my lord. So mother, that liability will not come to me, my lord, because daughter is the consumer, my lord. So far the number is concerned, my lord.
We are not before the consumer. Because of that, he has lost. He must have given the number to that. It is prohibited to give the number of the
No,
doctor.
but
He
then
may
how
not
come?
be in a position.
Then how come,
He's a
my lord?
retired person. He may not be able to use it.
Then how come, my lord, Airtel will know that he is using the daughter's number with the bank, my lord? Airtel will have no knowledge about this using the number, my lord. Even the fraudster, how come they know that daughter's number is being used in the transaction, my lord?
This is not a problem with the daughter's number. They daughter know many.
That's what, my lord. Unless you do compromise with this pin and all that, it can be not possible, my lord.
No, no, pin is not.
Pin is
For
required.
SIM swapping, is the pin required? For SIM swapping,
But,
pin
but-
required.
For my lord,
For SIM swapping,
Mhm.
pin is required.
pin is required, my lord.
For
Unless-
SIM
unless-
swapping,
No, pin is not required. Pin is not required.
these are internet banking. Once our internet banking is used, they will use the mobile phone to that effect, have what is required for them to have. First, if it is done not through YONO application, they will do it
Yes.
through internet banking. They have to know first his the user ID, then his passcode. These are the two things. Once these are, how will they get it done? They can have to register it. And what is required, as shown by them in that particular affidavit which they have filed, they only require the SIM. Nothing else. That SIM, and all the fall goes back to you.
Matter, but that is not possible without compromising all this account number and CIF numbers. Customer identification number is important, my lord.
So what?
To open up internet banking.
Internet banking, customer identification number now. You just need two things. The account. Then you, with the SIM, you can do it.
I have said the CIF number, account number, 5 digit transport.
Huh?
Malo the
5 digit
5 digit malo the branch code.
transport, is it not available in the internet?
But malo the our reply is CIF number and account number.
Account number,
Internet banking is concerned, my lord.
account number tomorrow, just for example, this particular file is there. Somebody sees the account number that this person's account number is 10958225308.
Malo, how can access the internet banking, my lord? The circular also I have.
I've seen that. The person who came out here, that is why initially when I took up the matter out there, I asked, how is it possible that without the person going out there physically, there can be an internet banking password? Then he gave up this particular circular, for which I've asked them to file this additional affidavit. I remember that. So you don't require many things. That is your specific cell. Now, if you jump out to Health Airtel, then you pay. You want to help the Airtel, help it. No, no. The thing is, or should we direct the SBI to pay and direct the tribe take action against it? Something has to be done against it. Because this thing which we have done, it's a serious thing, and this is going to happen. It has to be given manner in which it's a public service. He has taken for point out there that we are these things cannot decide all these things. In fact, that gives me a good idea. That this is a public function they are in. So under such circumstances, when you are discharging public function, anybody disturbed out there, risk gets to pay. So the best, I think, to give it to the try. Some actions to be taken, and then if any penalty is to be given, I think they will give. What do you-
I leave it to your lordship, but then we have explained in details about our affidavit, that how that has been happened, how
I
that
think
is.
let the try first look into that.
Let-
Try will do.
Yes.
And if there is any mistake committed by you, then it will be reversed. Right. I think the try needs to the try under the try. Telecom Regulatory
Regulatory Authority.
Yeah.
Right.
So it's directed
They
to
can try-
register a complaint against it, and then to decide as to whether it has been done in accordance with that, stating these are the things which have happened. I think that is a better course. Give it to try, let the try it, and if any amount is to be given, the try will decide to give compensation to the SBI will pay.
What is but my lord? Yes, and my lord, affairs also my lord, that the forwarding report, that police investigation report.
Try will even consider that the money which has to be directed should be paid to the prisoner or to SBI. You get a chance.
But my lord, that is my lord, for a moment my still affidavit is my lord. There are key ways regarding internet banking.
I have seen that internet banking, everything. You see, the first and foremost is person is a pensioner. Being a pensioner, this court needs to take note of that he first he take. Otherwise, if he is a person of like Mr. Manna in person, then obviously I would not have given. That would be, we are to take into consideration he is the pensioner. So first, his pensioner thing is a senior citizen we need to take care of. That is the first duty for which you will pay. I'll refer the matter to try for deciding as to whether the Airtel is at fault. If Airtel is at fault, then the liability, whether the amount which has been directed to paid by SBI to him should be realized. It is win-win for you also. Maybe delayed, but win along with interest.
There is so it means that the bank has don't have full money.
Huh?
And my lord, and here is a my lord, there is
So,
no fault of the bank, my lord.
has the bank stopped?
Yes, my lord.
Has the bank stopped lending? Has the bank stopped? No, Mr. Counsel. Has the bank stopped giving home loans? Has the bank stopped giving car loans? Or is the bank giving home loans and car loans without interest? There is not a fault of the, no.
My lord,
There is
here
no
is
fault.
everything was shared, my lord. And my lord, only because
For me,
the changing of the
no, Mr. Counsel, the fault does not arise of the bank, of the petition.
For a moment, my lord, kindly forwarding report, kindly look into what investigation officer says. Page 29 is there, my lord.
No. Mr. Counsel, I'm not saying. You are liable because of the RBS. Nothing more than. I'm not saying it is your fault. No, I'm not saying. But, therefore, I'm referring it to try against them. If these people are found at fault, because this is not a small issue, which is only to be done. Yeah, this issue would also be helped the banks in future also. I'm referring it to try to find out as to whether there is a fault on the part of the Airtel in issuing this swapping in this manner, which had resulted in the bank, without any fault of the bank, this court directing the bank to pay, for which the try has the power to impose upon them whatever may be. In fact, that is a direction which is very much required in the present facts, in the sense so that in future these type of things does not happen. I think that is the best course of action. Let the try decide, because try, I think, in that regard, whether it is the swapping and all these things and all, I think this is the best order which can be passed. We will have it on 12. We'll pass the order in the court. List the matter on 12 for further consideration at the top of this court further take note of that during the course of the hearing, Mr. K appearing on behalf of the SBI, has placed an instruction dated 7/3/2024, which is kept on record and marked with the letter Y. Because this is an issue which will have all India ramifications.
So many cases is
No,
now
no,
pending,
because
my lord,
no,
type.
if this SIM swapping is allowed in such a easy manner, everybody will do. So the question is not only that the Airtel, because here the problem arises for this court, which I have thought about it, to directly impose to the Airtel in view of the circuit. So let me ask, try to do. Just find out whether it will be try which can properly do it.
Right.
As to whether this aspect can be looked into by staff. So that on that day, for me, as far as I know, I think the try would be the best option. Anything urgent?
Mayor, please.
Yes.
Item 12 and 13, your lordship, these are fit for hearing, but have gone through the record. In case of item number 13, there is no LCR.
Why?
Because the call for on 8/7.
What is that matter?
The back record is not come.
12 and 13.
12 and
12,
12, there is a record.
the record is there. The 13 was not.
Records have not come. So it has, during the course of, while taking up the matter, the RSS 376 of 2017 and RSS 144 of 2000. During the, while taking up the matter, it is seen that the lower court record, LCR, of RSA 144 of 2018 is not available. Under such circumstances, the registry shall verify why the said records are not available and if need be, call for a state record. Immediately upon receipt of the said LCR, the matter be placed before the court for hearing.
Lordship, item 14.
Oh, yes, you wanted some important matter to be taken up. Which are
Lordship, that matter was not listed today, your lordship.
not listed?
Not listed.
Okay.
Matter interim order report.
Where?
Number 80. Then
Item number?
item number 80. 1.
1-8. What is that?
Interim order will expire.
What is this? FAO?
Yes.
Where is your other side? Item number 18 today. And anything else? Item number 18. Yes. Item number? 31. It's the matter on 2nd of April.
Lordship, item number 14, your lordship.
1-4.
A date may be, your lordship.
What is that?
Hearing matter, your lordship. Appeal for that.
TRP.
Lordship.
What is this?
Degree was in a favor, your lordship. The petitioner had come up against the same. The stay order operating.
Oh, landlord tenant.
Lordship.
When do you want?
Any date, your lordship. Thank you.
Okay, 2nd of April.
I think that.
What is that? Tell me. What do you want? Why? Oh, it has come by order. Somebody mentioned the matter. How can a hearing be come up for order? By order? Better I don't say.
Lordship, for item number 5, kindly a date may be fixed
It has come for hearing.
5.
Yes.
What did I take today? Why 5 was not taken up? Huh? Oh. We'll take it up on Tuesday. Item number 5. Okay? The whole map.
Number 7.
Item number 5 on 8. Okay? Yes, my aim is to finish 2 RSAs in a day. Yes. Rest are bonus.
Lordship, item number 9. It's an RSA, your lordship.
Yeah.
Can
Then
the date may kindly be fixed.
why? Will it come? These will all automatically come. Don't worry with these matters because these are from part 2. It has been taken up, so it will come.
Right, number 7. Can date is fixed in the next week.
What do you want?
Any date in the next week. 14.
14.
Oh, this
7.
7.
Okay. On 14th. Let's try on 12.
12, I will about this.
14.
14 law.
In the field, that's a copy of the plain in WS, there is some mistake. Type. So the-
Was this matter heard earlier?
No,
no.
it has not been. Because there is some typing mistakes, some translation mistakes are
in
there.
the
So he has corrected
plain
all
in
these
WS, I
things.
corrected it.
And
Can
anything else? Yes, item number 18
7,
is
7.
7.
yes. What is that matter?
7.
Item number 18.
Oh.
What is this? What are you challenging?
Injunction matter, my lord, the trial court dismissed injunction petition.
Huh?
Trial court dismissed injunction.
Refuse.
Yes. Okay. Injunction.
Trial court refused. What was the refuse? What was the injunction asked for?
This will let's be a protocol matter. I should but declare it on. Confirmation of
Why is it not maintainable in law? What are you asking for? Let us see what is your case. Where is your injunction application?
yes. Let the lordship and the injunction petition at page 34. Alert petition has been
Not
dismissed.
to interfere or disturb the possession of the petitioner plaintiff over the citizen and past. So you want a status quo.
Status.
A status quo as regards possession. Why it has been rejected?
Rejected my lord on the ground that earlier one this case was filed for injunction. That was dismissed.
Huh?
That was dismissed. Subsequently, my lord, what happened? Many events, subsequent events have taken place.
Wait.
We applied for amendment. Amendment was allowed.
Who is in possession?
We are in possession. My lord, all the three principles, prima facie case, balance of convenience, and irreparable loss have been decided in our favor. But as the earlier petition was dismissed, rejected, so this petition has been dismissed. For a subsequent event, my lord, we brought before the court and amendment was there.
Lordship will find that page 132. Prima facie case, garage for convenience and loss of irreversible loss. All these principles are decided in our. But it has been discussed only for that. We can lynching, I thought the land has been sold to a third party. So we filed amendment. Amendment was there. Not to find that page 33, 133. We are in possession. Finding has been given.
What about the earlier suit? What happened?
In earlier suit, finding has been given that the third party who entered in this and so purchased the land during pendency of the suit, they were not made party. Technical ground, they were not made party. So the prayer was.
This is 5 years before.
Yes,
And when was the agreement to sell?
my lord, the agreement was, my lord, it was, my lord,
Agreement for sale was when?
yes,
What suit
my
did you
lord-
file earlier?
my lord, 22/12/2011, formally land was delivered to the petitioner appellant. Page 38, your lordship will find. It was formally delivered. Page 38.
Now, after
Formally
paying,
it
this
was
was done in 2011.
My-
Then the sale took place, was ready and willing.
Yes, yes. it
But
was
where is,
2018.
what about the earlier suit?
My lord, this is the suit, my lord, 32, the title suit 32 of 2018.
Ah.
Along with this suit, we filed the injunction petition.
Hmm.
That was rejected.
Why?
Rejected on the ground, the third party who purchased the land during pendency of the suit
Was
were
not.
not made party.
Then,
On that technical ground, our earlier injunction petition was rejected.
and then you file a fresh one.
No, not my lord, we filed amendment of the claim.
Ah.
Amendment was allowed. After allowing the amendment petition, we submitted the amended claim. Thereafter, we filed this present injunction petition.
So therefore, you file a second
Second.
injunction. So
Court
this,
has
Let us see the earlier order.
Yes, part by res
No,
judicata.
the earlier order.
Yes, the earlier order, your lordship will find. But the affidavit in opposition filed by the
Where is it?
respondent.
You have not enclosed it? You have not enclosed it here?
No, my lord, the affidavit in opposition. Earlier petition order.
Is there an affidavit in opposition here?
Yes. They have filed the affidavit in opposition. Your
Yes,
lordship.
কিবা আয়ে আছে নেকি তাত?
Yes, that is.
Oh, yes,
that
got
is
it.
one.
Huh? No. Where is the affidavit in opposition?
Annexure A, your lordship will find the earlier dismissal order, like the dismissing order. Temporary injunction is rejected. Therefore, temporary injunction is rejected.
Affidavit in opposition where?
Yes, affidavit in opposition, they have.
Where is that affidavit in opposition? In which case?
My lord, in FAO 43 of 2023, it has been filed, my lord, in
There is no affidavit in
the
opposition here.
misstatement. IS civil 2-1.
No, Mr. Counsel, there is no affidavit in opposition.
In the
Affidavit.
IA,
Yes. Where is that order?
yes, that, my lord, will find it annexure A. Annexure A, my lord. Only one annexure.
Find that there is the time it is required. It is not. So this was not ground on technicality.
Yes, my lord, on technical ground, non-jointer of part. Supreme Court does not
No.
mention.
You have not come up with clean health. Have you challenged this order?
My lord, this order, if you would have challenged my lord. Yes.
Hello, we do one thing. We'll hear it again on Monday. It's the matter again on Monday for further hearing. 2 p.m.
Not. What is the third sheet?
I picked some matter on Tuesday. Na?
Lord, she's mentioning for 8. Next Tuesday will be 12th. In that case, can item 5 be on 19th?
No.
Then both the matters on 12th.
So if I can do 2 matters, then why can't you do? You have a long weekend. Tuesday.
Obliged.